Laptop speakers on mute. Good. Yeah, I'm not seeing.
Sorry, hold on. That's six.
I'm watching for Robin and Lance and Anne. Yeah.
And how is mine?
There's Robin. It's normal on my laptop.
Yeah, actually, it's normal on mine too.
It's something in the setting for the TVs, I guess.
Of the view. The view of us.
Yeah.
Yeah. You're Can you change the view at the top?
Just yesterday, but I actually just wanted to do things that way.
That might not be it.
I'll never tell if I'm really kidding.
There was some pretty substantial.
There was a lot.
Updated.
Yeah, we got all the planning commissioners here. I'm not seeing Anne or Lance yet.
But I saw Lance.
Did we identify
Oh, there's Lance. Yeah, I see him.
where Matt was? that
Matt will not be
Yeah.
able to be here today. He said he had a funeral.
Yeah, he's there. Okay. Shall we?
Good boss.
All good? Nicola? Nope. All right, good morning. The joint work session of San Miguel County Planning Commission with the Board of County Commissioners of Thursday, March 13th, 2025 is hereby called to order. It's like 9:32. I'll note for the record that the Planning Commission is fully represented with the exception of Matt Bama. And for county commissioners, we have Galina and you said we had Ann.
Lance is here. I don't see Anne yet.
Okay. There's Lance.
Yeah.
Ann hasn't joined us yet, but we'll go ahead and commence. This is a work session. I have a feeling the emphasis is going to be on the word work. We do have some public here just to, again, outline the process. Staff will represent and present on the changes to this current working draft. Commissioners will, of both boards, will query them with questions pertaining to the process and the information provided. We'll probably take a break at between 10:30 and 11. And then we'll open it up to public comment. But we're sure to have some. So with that.
And I do see that Commissioner Brown is on now too.
So
So
Brown has joined us.
we've got everybody who's able to be here today.
Good.
Okay. Okay, so, good morning. This is our, sorry about my title slide. I forgot to change it after I presented to the Open Space Commission. This is actually, mining regulations with the BOCC and the Planning Commission in a joint work session on March 13th. Recycling is good unless you forget to change things. Actually, let me get out of this for a moment. That's not my recycled one. That's the wrong one. Ah, now we're going. Okay. Okay, sorry for the little mix up. There we go. Right presentation. So the meeting purpose is to review the draft regulations for mining. As always, we will not be discussing specific properties or potential projects. And then would like to remind you that we'll be considering regulations for oil and gas, logging, and geothermal at future meetings. And then also we did adopt the regulations for solar energy facilities actually September of 2024. And that included some general provisions related to natural resources. By way of background, in 2019, the county commissioners requested natural resource regulations be updated, and they asked that mining activities be subject to a two-step review. So we did the code amendment for that two-step review, but it took us a little while to get going on the land use code amendments for natural resources. So we began those in 2023 with a community open house. And obviously a lot of that talk was about solar, but we did ask about all the natural resources in general. Also in the last several years, we've had some projects. We've had the 2021 Borough Mine Reclamation out near Slick Rock. And we also have had 7 mining applications in the last 3 years, or mining exploration applications. In 2024, we did adopt a land use code amendment for mining hazards, and this is really intended to be used for development on properties with mining remnants. Typically, somebody wants to come in, for example, build a house on an old mining claim. And it doesn't really fit under this. And then section 6-1, I mentioned the general provisions were already adopted. In our January work session, we began with an overview of federal and state mining laws and regulations and their relationship to local regulation. And then the key discussion items were the definitions. Were we properly defining the terms, especially, exploration, mining, what was the difference between reclamation and remediation, the review process for reclamation only projects and the review process for exploration activities. Then we had a few other, a lot of other smaller things, but those were really the bigger topics. So we continued to take comments on our first draft until January 22nd. And then also since the last meeting, staff and our consultant, Tori Jarvis, we met with both BLM and DRMS staff, Division of Reclamation and Mining Safety, Mining and Safety, excuse me. And then we issued our second draft on February 7th. And then we've had a comment period open since then. So once again, this is a regulatory approach. The intent of our mining regulations is to mitigate the impacts of the proposed activity. An applicant for mining will be required to provide reports, plans, and studies that analyze impacts of the project and explain in those materials how the applicant will mitigate those impacts. Application requirements may be waived or modified based on the scope and expected impacts of the activity. And materials prepared for federal and state permits may be submitted in order to avoid preparation of duplicate studies and reports. And in many ways, that's actually preferred. There's a lot of good information that goes into those reports, and really can't imagine a situation where they wouldn't be acceptable to us.
Yeah, I think you'll be able to tell, but in the second draft, this was always the intent, but we did work to make that clear. We repeated it in several places and tried to, I don't know, just further explain that you can waive certain materials and instead substitute the state or federal applications. So we really tried to make that clear, since some of the comments certainly seem to be asking about that.
Yeah, and then, as always, anything that's a one-step or two-step review goes out to all our many referral agencies. And we do have an extensive list, and if they provide conditions to us that are necessary to meet their needs that fit within our scope, we can include those as conditions. You're very used to getting those, for example, from CPW. And then we wrap that into our conditions. So, I mean, this, as we've talked about, there's an interrelationship of federal law and permitting, state law and permitting, and then local law and permitting. So these will apply to private mineral rights on private land. It'll apply to mineral activities on state lands. And they will also apply to private activities, so permittees on federal land, because the regulations are focused on mitigating impacts of the activity, not on dictating whether or not mining may occur on federal land. The mining regulations are intended to complement and not conflict with federal and state regulations. We recognize that federal and state regulations may preempt San Miguel County's regulations. We understand, the Colorado Division of Reclamation, Mining and Safety, or DRMS, is the primary permitting authority for mining in the state. There may be other agencies that have permitting requirements, such as water quality, air quality, CDPHE, all of that. And then federal state permits will still be needed for mining activities on private land, and there may or may not be a need for federal permits. Application materials, as I said, prepared for federal and state agencies may be accepted by us.
Go ahead. There's a memo in your board packet that has more information about preemption in particular and the different types of preemption. You did receive comments suggesting that some of your regulations may be preempted. Would it be helpful to you all to review briefly the types of preemption and the way that we look at these regulations not being preempted? Would that be helpful real quick? Or
it'd be helpful to do. I'm just not sure. Do we want to let Kay finish her presentation and then dive into
yeah, that's fine. I just knew this slide was kind of the preemption slide, but I don't mind.
I'm
We can say
quite sure we're going to be talking about.
Yeah, exactly.
Yeah, and the important thing, that very first one, in addition to projects on private lands and state lands. So these regulations have a very broad application to a number of situations, across all types of ownerships and property rights. So under mining activities, we've got three different activities. We've got exploration, and then we've got reclamation not associated with a mining operation or exploration. For example, historic remains or mining sites. And then we have mining operations, and that includes mining, processing, and remediation and reclamation associated with the mining permit. So work that's done in the course of their activity. The draft regulations will be part of Article 6, so a whole new Section 6-3, and in addition to the other natural resources topics. It lists zone districts where mining may be permitted. It contains all application requirements according to the type of activity and all review standards according to the activity. And each application requirement corresponds to a specific review standard, so it's very clear why we're asking for the information that we are. It'll make it much easier, I think, for applicants to prepare their application, also for review of applications, because you're looking straight across. You're not having to interpret as much. There are limited cross-references to other sections of the code to avoid errors and omissions. A notable cross-reference is lighting, because we have our dark sky compliant lighting section in section 5-7. We have chosen not to repeat it across multiple sections. However, wetlands, which has its own section 5-22, I think, we instead restate wetlands in this, and it made sense to us. So just kind of the highlight of some of the definitions. We really did a lot of work on those in the update. But exploration is the act of searching for or investigating a mineral or construction material deposit. And then it goes on to provide examples. A mining operation is the activities associated with development, production, and or extraction of a mineral. This could be a mineral mining operation or a construction material mining operation, like gravel. And then there are several subsections under the mining operation definition where it goes into a lot more detail with examples of what that may include. So one thing we did is we really no longer use remediation. That was causing a lot of confusion. And so what we use is reclamation, which is the employment of procedures during and after a mining operation pursuant to a DRMS reclamation plan, or during and after exploration pursuant to a DRMS approval of a notice of intent. And then restoration is the employment of procedures designed and conducted pursuant to a county permit for areas outside the boundaries of an approved DRMS reclamation plan. So restoration is a new definition that we added, and hopefully this will, kind of clear up the confusion that was in there. Review processes. So mining operations, as previously proposed, two-step review. So it goes to the Planning Commission for a recommendation, the Board of County Commissioners for final decision. Exploration is a two-step review. Minor exploration would be a one-step review. So I've highlighted this because this is a change. And minor exploration is defined in the code with its limits in area, number of holes. So you guys had asked that it be a one-step review instead of administrative. So we made that change. And then reclamation only operations, we had also previously recommended that be administrative, and you asked that it be one-step review. And obviously it has to go through the federal and state permitting requirements. But the activity notice for state and federal reclamation projects continues to be in here as they provide notice to us, to the planning department. And as an example, the work that's been undertaken on the valley floor recently by Forest Service and EPA, that would be an example where we would get an activity notice. So it really kind of depends on who's carrying out. If it's a private property owner carrying out some sort of reclamation on their own property, then we would do the one step. Or a private permittee outside of their mining permit. So there's a number of zone districts where mining and exploration is allowed. And that includes the forestry, agriculture, and open, which is the light green on this map, a significant part of the east end of the county. Rangeland grazing, which is that smaller brown area up on Wilson Mesa. Wrights Mesa and Wrights Mesa rural agriculture, which is the darker green area on the map. The west end, which is over half the county, and it starts just west of here in Norwood and goes all the way to the state line. And then, the high country area, which is that light green color up along the, in the high country on the east end. Mining of federal minerals are permitted in all areas regardless of the zoning. And mining of privately owned minerals may be considered in other zone districts on a case-by-case basis. We expect that that will be very rare. But hypothetically, say if there were a low-density zone district where the parcel was big enough to have commercially viable gravel, we could then consider that application. But most of our other zone districts are very small lots.
Could you clarify what federal minerals are?
That is where the federal government owns the mineral rights. So we have federal lands and they own the mineral rights under those lands. There's also private property where there's a federal reserve mineral rights. So when those lands were acquired by the private entity, the federal government held onto the mineral rights.
So it's not specific to what kind of minerals, like vanadium or uranium?
No, it could be anything that's considered a mineral.
And do you have a map that shows that in the county?
No. That would be a very challenging map to make. Because we'd have to get into researching all the privately owned properties to figure out if they have a split estate on their minerals.
Hey, is
anyhow.
it typical for private properties to also own their mineral rights, or is it more typical for the federal government to have the mineral right reserve?
It goes both ways.
So like 50-50 kind of?
Dan Van Horn of the BLM has just asked if it'd be helpful to have that map, and the answer is yes. We'd appreciate seeing that. Because you guys know where your mineral rights are.
Yeah, we've got access.
I think that would be helpful.
Yeah, where we have federal.
Yeah.
Federal surface, federal minerals and.
Yeah.
You know,
Great.
federal minerals under, non-federal surface.
Yeah. So, yeah,
Sorry, I mean to derail you.
Yeah. I just,
Yep.
kind of a weird aside, but, in my family, our mantra is do not sell the mineral rights. We may sell the land, but we hang on to our minerals. It really depends on the private property owners as to, whether or not they transfer the minerals and the terms of the sale.
Thanks. Kate.
So the application materials and review standards, so we've got two sections. One's application, one's review standards. Exploration and reclamation only are in section 6303, application 6304 standards. The two activities were combined and moved ahead in the section 6-3 because they are our most common types of applications and also what typically comes first. And then you had also asked that the reclamation application materials and standards be enhanced. So these two activities now have the same application materials and standards. And then mining operations are covered in 6-305 for application and 6-306 for standards. Certain required plans may be necessary depending on the type and level of activity, but that includes emergency preparedness and response plan, spill prevention control and countermeasures plan, hazardous materials management plan, restoration plan, and these plans would become part of the development approval. So when the resolution is adopted, they'd be specifically referenced as being part of that approval, and they would always be there.
Just to add, a revision in the second draft that's before you is that the hazardous materials management plan also includes now, the management of mine wastewater also.
Are these plans required only for mining operation development applications?
They can be required for exploration and reclamation if needed. Some of these you know, as we've seen, with exploration, you know, they're in and out pretty quickly and there really isn't a lot of hazardous materials. And, you know, so it's a smaller component.
The
So it would
the
be-
emergency preparedness is in both.
Yes,
So it would be a normal part of the pre-application review process to identify. No, you don't need that. No, you don't need that. Yeah, we will need that.
yeah. And, you know, quite frankly, we ask even on the smallest exploration, what are you doing, you know, in case of, you know, like a fuel spill? How are you, you know, and, you know, wastewater? What's your sump design? You know, how are you controlling stormwater so that, you know, the drill cuttings don't, you know, go off-site, things like that.
So plan might actually just represent responses.
It could be,
Okay.
yes. And then all the way up to, you know, if you had an operating mine, it could be a very detailed document.
One of them.
So I'm not going to read the whole list, but this is all of the various standards we have for all 39 of them for mining operations. And it is very extensive, all the way from applicant expertise up to compliance with plans and studies and everything in between. Through the life of this, for example, we have increased we've added information regarding terrestrial plants because there can be sensitive species there. We did incorporate some very specific recommendations from CPW that actually were quite consistent with what we had in solar. We've made some amendments throughout blasting. We simplified it because there were some things in there that we simply didn't need to know. We need to know if they're going to be blasting, when they're going to be doing it, and how they're going to be notifying the neighbors, and also notifying probably the sheriff's office. And then mineral exploration reclamation only. It is a more abbreviated list of standards, but again, covering all of the you know, significant things that we know from experience that we are interested in. And as I previously noted, minor exploration activities are subject to a one-step CPC review in this draft. And then reclamation only operations, as I've said before, the same application materials and review standards as exploration. And if it's remediation and reclamation associated with the actual mining operation and mineral exploration, exploration is reviewed as part of that permit. Reclamation and mining operations is under the purview of DRMS, and reclamation only operations are subject to one-step review with the activity permit for anything undertaken by state and federal agencies. So a little redundant there. Reclamation and bonding. The reclamation bonds are held by DRMS. The respective federal land managers might also have their own bonding requirements. The county may require financial security for impacts outside the DRMS approved permit. For example, and most notably, it usually involves construction, maintenance, and remediation of the haul routes. You know, we don't hold duplicate bonds. If it's covered by the federal or the state bonds, we don't require bonding for that because that's their purview to make sure that that work is done and to handle the financial security. I'd also
One of the places that you are explicitly preempted in
yes.
statute, one of two, I would say.
And I would add, you know, people, you know, from the industry side have brought up concerns about, you know, when bonding should be required and how much it should be. And if appropriate, we can actually structure agreements that are phased. So we get different bonding at different levels. You know, for example, if they know that in the future they're going to be doing this part, but they're only doing this part right now, we can work out an agreement with them that they give us a bond for this amount, and before they can start that next part, take some good agreements, but before they start the next part, that's when the financial security for that next bigger part kicks in. So, you know, there's, you know, although this looks like a, you know, a lot of, you know, it looks very kind of strict in its regulation. The application of it actually does allow us to respond according to the scope. Then we also have provisions for notice of temporary cessation or termination, requirements for an annual report, and wherein, you know, they're telling us what they, you know, what they're doing and how they're meeting the standards. And then also transfer of permits. So if it's sold to another operator, we want to make sure that that operator, A, is updating the financial security, and also B, agreeing to comply with all terms and conditions of the approval.
So generally, these SUPs would run with the land and not with the owner?
That's correct, because this is, I mean, this is a land-based activity, and, you know, it's,
A certain amount of volatility is built in. I
yes.
guess, in some respect.
But yeah, you have to expect that, you know, a mining operation could be sold to another entity. So in terms of referral and review, as I mentioned, these were first posted on our website on December 23rd. The comment period was actually held open until January 22nd. So in the middle of that, we had our first work session, but we continued to take comments. And then we turned around and prepared the second draft. We published that on February 7th. We asked that written comments be submitted by February 28th, but we continued to take comments all the way up through yesterday. And also in that time, staff and the consultant met with both DRMS and BLM staff. And then I also met with the County Open Space Commission because they did have some questions. And then comments have been received from BLM, DRMS, CPW, Western Small Miners Association, Colorado Mining Association, Four Corners Broadband, Great Old Broads for Wilderness, Sheep Mountain Alliance, and Inform, the County Open Space Commission, the Town of Ophir, and a number of citizens. And I'm not going to present a detailed response to all of the many comments, but I'm going to let Tori talk about it. And you do have a memo in your packet where she hits kind of the high level response to comments.
Okay, Tori, that's your memo of March 6th.
Yes, March 6th. Yes, that's right. So it's labeled as attachment 1 in your board packet. Looks like it starts on page 8. And what we tried to do is give some high level, like things that we heard by multiple, you know, commenters, and also things that generated some revisions or that we felt, you know, warranted a response. It's great. There's a lot of people keeping an eye on these regulations, but it really meant that the scope was not that we were going to be able to respond to everyone's individual comments. So we tried to give some high level comments, and I don't think I'll go through the whole memo with you all, but what I did want to point you to is page 11 of your packet. I think it's page 4 of the actual memo. You can see from Kay's timeline that since we last met at your last work session in January, we received more comments on the first draft that you all looked at on your first work session. So that generated some additional red line comments that went into the second draft. We've also, since we last met, have received comments on that second draft. And so what I wanted to draw your attention to on page 4 of the memo is that we've already started flagging several revisions based on comments that we received on that second draft that, you know, this is the first time you'll be talking about it today in your work session. So we wanted to give kind of everyone's a preview of some of the thinking there. So I think that's what's I think everything else, at least you've had access to and the public's had access to for a long time, but this is kind of new information there. Some of them I would describe as more tweaks, not very substantive. So like DRMS, for example, recommended a revision that's more consistent with their own regulations for minor exploration projects. Their definition of it's actually what isn't even considered exploration in their regulations is if there is a project that involves 2 or fewer areas of surface disturbance below a certain size. You actually don't even get a permit from DRMS, but for you all, we understand that there's still a desire to hear and to review all of the exploration projects, but we know that a minor. Anyway, it matches up better with their regulations there. So another one that's come up previously, and admittedly, we really just missed putting this in red line in this first draft, is many commenters noted that there's the review of alternatives for you all to look at alternatives and decide this is the best practicable alternative. The more that we thought about it with the comments we received, it really, I think we agree with the commenters basically that in the circumstances of mining where the minerals are, that may steer you on a path that doesn't really make sense to evaluate the alternatives when, you know, that the site is chosen because of where the minerals are. So we're recommending deleting that one. And we also did look through and consider that we think that the impacts, the way that we have all those impacts listed that you can consider would still cover you of, you know, what's going on that proposed land use and how you can address those impacts without looking at alternative site locations or something like that. That wouldn't be appropriate. I mentioned, part C on page 4. There's one part that we recommend taking out. DRMS pointed out some problematic language about heap leach mining, and it's another place where I think we were getting too specific, and I think you're covered with impacts of different techniques and you can look at without calling out a specific technique. So we recommend deleting that one. Okay, I had to remember where this came from. D on page 5, the definition of production. So just to remind you all, for most of the definitions, there were a couple that we created from scratch only if they didn't exist and we thought it was appropriate, but mostly we rely on DRMS's definitions because DRMS permitting applies on federal, state, private land. So that's the one, those are what are going to be like matched up the most with projects that you're looking at. So we thought DRMS definitions were the most appropriate. They pointed out that there is a part of their definition that of production in particular that we think we should just get rid of. It suggests that the county is going to make some sort of determination on what level of activity would rise to be production. And we really think it's most appropriate to just defer to how DRMS does that. So strike that. Financial security. This was another just tweak, I think, to be clear that we don't think that there's a shall. So it says the county shall require a financial guarantee, but we don't think that the county will always need a financial guarantee for different types of exploration or reclamation only. So we just wanted to change that to a may instead of a shall. And then the very last one is something that got pulled in from CPW comments for large scale solar that doesn't need to be there. So those are, I guess, 6 edits that we're seeing already to this draft too.
And there's some smaller edits in here too that we keep finding.
Can you stop sharing so I can see everybody? I'm not sure.
Yeah, I actually only have one more slide.
Oh, well, then finish.
So yeah, what we're looking for here is direction to staff regarding any further amendments to the draft regulations. And also provide direction to us as to whether an additional work session is needed or if the updated draft regulations, so there'll be one more draft after this as we make these changes. If we can set that for consideration, send it out to our referral agencies once more. So yeah, that's all I had.
Okay. So just to clarify, the only actions to be taken today would be recommendations for additional changes, additional study, and at most a decision about whether to have another work session or not. That's pretty much what we'd be looking at from a planning commission standpoint. county commissioners do their own thing, so to speak.
Yeah.
Okay, and then of course the public will come to the fore when we've done our questions and answers part. I have a few. Anybody want to jump in first?
I have a kind of general question to start, maybe.
Please.
It came up, there were some questions about kind of the order of operations, about whether the county expects that applicants would first get their permits from DRMS and then come to us, or vice versa. And I was wondering what you guys are thinking about that.
It could go either way. As you know, we found with some, that the, having the other permits in hand, really help inform us. Coming to us first, can perhaps provide, a clear response for us to those agencies on things that issues we see. It's really up to the timing and, how the applicant wants to do it. There's no one right way.
But they seem to indicate that submissions to DRMS can change very substantially through their permitting process. And that we need to be aware that if they're submitting to us first. So I guess I was wondering about how we expect to deal with that.
Yeah, it's gonna be one of those things that if they're, way early in their process and there's the potential for substantive changes, we're going to have to be aware of it and respond accordingly. I can tell you from experience, we're usually the last people they talk to.
Okay, I was just curious.
And the other reason it's hard to, I think it's hard to, say the way that it'll always go is there's probably 9, I didn't count again. I feel like I counted for the last work session, but I'm just going off the top of my head, maybe 9 different DRMS types of permits. And some of them are really just notice and in a certain amount of time. If you don't hear back from DRMS, then whatever your plan is you submitted is good to go. So there will be times where you all are looking, I think, in more detail at an application than DRMS, like those minor exploration projects, for example, may not be getting any DRMS, or they may be getting that notice for exploration, but they won't go through as many rounds. And I think those are the times where it would make sense for you all to go first. Then they incorporate what they learned from you all into their DRMS application. The mining, a big mining operation, it probably makes sense for them to do all their really technical work with DRMS first and then kick it to you all.
That makes sense.
And one of the motivations of the former, where they might come to us first, might be because there's some local conditions on the ground, like we all know there's inadequate roads into that spot or something like that, where it makes sense to come to us first if they choose to.
Yeah, good point.
Well,
Hey,
two large
can I,
things.
Lee, sorry, can I jump on top of that one too?
Yeah.
I was just wondering if Kay thinks it would be worth putting language in there to the effect that if DRMS submittals are used in their submittal to us, but then those submittals change significantly over the DRMS review period, they need to be resubmitted to us so that we have the latest and greatest version?
If we were in a situation where it could happen, we would most likely have a condition in the resolution stating that. So you don't have to put it in the code. That's just a matter of us, recognizing each time what's going on and the appropriate timing.
Okay.
Okay, so in all the feedback, and I wouldn't pretend that I've read every one of them, all of it, but so far, redundancy and preemption seem to be the major themes of concern, particularly from the mining community. You've spoken a little bit about preemption, and it appears that we're taking, I can call it this, we're taking the documentary tactic of articulating our concerns and areas of study, and then recognizing that some of these may be preempted and we have a process to allow for that preemption. Is that a fair description of what we're talking about?
Yes.
Okay,
in some ways, I guess the way I would frame it, I think is a little different than you had it on your slide, but so I don't think that any of the regulations, the way we have drafted them, are preempted on their face. What's going to happen, and I can name the types of preemption, but what you have to be careful of is when a case comes before you or a project comes before you and you are addressing impacts, these impact-based regulations, you're addressing an impact, the applicant will provide to you a range of mitigation. What you have to be careful of is you cannot get you can't have a prescriptive requirement that conflicts with a state requirement. And that would be, so there's three types of preemption express. So there's two places in the state's mining statute that say you cannot do this. You cannot have regulations for reclamation, and you cannot have bonding for reclamation. The state's the only one that can do that. So you're preempted. Your regulations are very careful to call out that you are not doing that. So we think you're definitely good there. There's implied preemption where the state may imply that there's no other room for you to regulate mining. That's really not the case at all for the mining regulation, because there is language in there that says applicants also have to get their land use permits. So that's pretty clearly not the case for mining. So then the third thing is conflict preemption. So that's where you're in this case with whatever mining, you're permitting, are there any of your requirements that cannot possibly be completed without conflicting with state requirements? So I think it's a little different than, like, oh, something written in here may be preempted. Nothing written in here is preempted by the state. In our review of case law and our review of everything, I would say that we disagree with the Mining Association in like suggesting that. I don't know. I wouldn't say that they specifically call out something that's definitely preempted, but they suggest that. Where you will be careful in the future is when you're actually permitting a specific project, you will have to be careful that your requirements do not conflict with something in the DRMS. So the one place that's the most prescriptive in your regulations is setbacks. You have 200-foot setbacks, but even after that, you have a sentence that says that, you may accommodate other setbacks based on, the applicant making a good argument as to why. So it's like 200 feet is the default, and then the applicant could give you other reasons why. And part of that is so that you don't conflict and have this 200-foot setback that is inflexible and conflicts with something that DRMS is permitted. So those kind of prescriptive number standards are the ones that really get wonky. And so you have some comments from folks asking for different setbacks, larger setbacks from different areas. And I think that is where you start getting in danger of having something in your regulations that is already going to be in conflict with DRMS. So that's that. Hopefully that helps set the way that we think about how preemption might pop up for you all. It would be in the future.
okay. What happens if the federal or state participant in the process steps back or decides not to perform their expected duties? So to be specific, suppose the EPA says we're not gonna do EPA, we're not gonna do impact statements on mining.
Mm-hmm. Yeah, great question. So I think that gets to your other like overarching comment on redundancy and why I think there's two kind of options. If you expect to get our DRMS permit, you could say just turn in your DRMS permit. What we chose to do is be redundant, take a lot of the same things that you would have in a DRMS permit, but require it separately, really getting at this exact reason. Like, you have the authority and the ability to ask for whatever application materials you desire as a local government, separate and apart from the state or federal government. And so that redundancy is like, the intent is that an applicant could give you their other application, but if those other applications fall away, you have a full set of regulations that it doesn't matter. It doesn't matter. Like, if the federal government isn't doing what they were doing previously, you still have your regulations in place.
There wouldn't be an instance where the federal government could step in and prevent us from applying our local regulations
I wish I could say that, but that's not necessarily true. Something could change. The current law does give you authority to do all these things. Yeah, it would take a change possibly in regulation, but really preemption is going to start at a congressional change to like the mining law of 1872, which hasn't seen very many changes since 1872.
Remarkably resilient is.
Yeah.
Uh-huh. Okay. Other questions?
Yeah, to
About-
piggyback on that one, Lee, that you were just discussing, this is Hallie Simpson. Tori, can you speak to another example? I know water, so I'm going to dive into water. We're asking for water quality data and effluent permit data. My understanding is that that's regulated by CDPHE, Water Quality Control Division. It's not our purview, but we want that information. Can we do anything with that, though, in terms of approving or denying it a mining application, other than having that information to use as an evaluator for downstream impacts or, for scientific research or whatever?
Yeah, what you just described is you're using that information. So that is another place where local governments are clearly preempted from regulating the discharge of a point source into a water. And so that's what the Water Quality Control Division regulates, is this very specific point source into a water of the US. They do some groundwater regulation too. So you would not be changing the terms of a discharge permit in any way, but you can receive that permit. You can ask for really any sort of materials you'd like in your application to help you inform that broader look at impacts to water quality. So hopefully that helps. Yes, you cannot change the terms of like a discharge permit, but those may not be the only impacts to water quality that you want to consider.
Right. And so then if we do see downstream impacts because of the water quality data that we've received, we also cannot ask for a bond for reclamation efforts downstream that's above and beyond what DRMS might be requiring. Is that correct?
You cannot, it will depend on what DRMS defines as their permit boundary. And they look at the boundaries of where site disturbance is occurring for mining operations. So if you are identifying impacts outside of their permit boundary, I think you could. And that's where, you could hire us again, but we won't be around, but Maura knows to look at that, and that's where your attorney, and if you need to hire outside expertise, I think that's why it's important to do that in those specific cases.
Right. So receiving the information is still useful to us as a tool.
Yes.
Not downstream, literally and figuratively. So for future information.
I would say so. Yeah.
Great. Thank you.
Yeah, and really, honestly, we didn't put anything in there that we didn't think would be useful to you all in evaluating those impacts. That philosophically, we would not bulk up an application unless it had usefulness. And some commenters, pointing out like the blasting plan was a good example of a place where we went back and clarified that. Okay. And I think the groundwater is another place where we did look at clarifying that we would not expect every applicant to do some really in-depth groundwater study to give us all this information. So we added something like, existing available information. I think we did that at hazards also, or geologic hazards, to say existing information that's available or not.
Right. But I guess that's another place where could we require a groundwater well?
I don't think you could require a groundwater well. You may be concerned about some impacts outside of what the state engineer's office would look at to neighboring wells, and you may require additional monitoring to document, no impacts to those wells, something like that.
And then it would be on the applicant to figure out how to get that data.
Yes, yeah. And that really is a fundamental piece of these regulations too, is why the application materials are so detailed and the standards are less detailed, is you're really putting the applicant is the expert. So you're asking them to give you all this information and explain how there are not going to be impacts. They'll be avoided, they'll be minimized. And if they can't be, that they'll be mitigated. So yeah, exactly. You ask for all this information, the applicant gives you, their best assessment of impacts.
I have a question related to this preemption topic.
Yes, please.
When we talk about cumulative impact, I guess I'm wondering like how much, it was brought up several times, like, what does this mean for an applicant? But I'm also wondering how much of that has to do with the applicant, how much of that has to do with what we're able to do when we're reviewing and we're looking at potential cumulative impacts to the whole county. Are we allowed to consider, if we've already permitted 2 mines, whether there's a cumulative impact that then makes a third application different? Are we not allowed to do that because of the federal regulations? How does that work?
You absolutely are allowed to look at the cumulative impacts. You do not have you look at cumulative impacts now in your land use code, and Kay can speak to that a little bit more about how that works perhaps. But there's no, even if you hadn't said, and I think I remember in solar, there was a desire to specifically call out direct, indirect, cumulative. And, that phrasing is also used in NEPA. So if you live in the world of federal environmental regulation, it may be, I think there was a lot of assumption that meant that you have to do this huge assessment. Local governments kind of inherently do this anyway, I would say. So you don't have to even call it out. There's no limitation on your ability to look at what happens if there's 3 other mines already permitted. What's that impact to neighbors instead of 1 mine? That's like just kind of inherent in your land use, like the way that you would consider issues for land use. So there's nothing that stops that anyway, but I think you felt like it would be, helpful to call it out specifically. The state, DRMS, developed, no, not DRMS, sorry, we just did a cumulative impacts rulemaking for oil and gas, so this will come up more in oil and gas, but the state can have limitations on what they can consider for cumulative impacts under statute, but just because they have limitations on what they can consider, unless it's specifically said this is all local governments can consider, which it doesn't, you don't have any limitations in statute on considering something like that.
Well, that said, it's prudent for us to have something articulated. I know this came up in our discussions and efforts over housing and development of housing developments, that we need to assess their cumulative impacts. And, we've been trained not to make decisions based on anything but the code.
Yeah.
So,
And so we talk about, using these regulations to determine how they impact the county and the county's facilities. One of our most notable examples is roads. So, the first mine comes in and we assess, their trip generation and road design, and can it handle those trucks and everything. Second one comes in, we evaluate it again, adding them together. Third one comes in, and all of a sudden the volume of traffic is so high that road cannot handle that level of traffic, whether it's, road width, road surface, design, curves, grades, site distance, all of that. And so that would be an example of, where we would clearly be in the county's purview of cumulative impacts.
So would it be fair to say that any of the impacts that we are assessing for any application, not just mining, could be the basis for an assessment based on the cumulative impacts of that particular impact, like traffic was your example.
Yeah.
But water quality might be one, air quality, or who knows.
Yeah.
So anything we can regulate for cumulative impacts.
Yes, and that's why that's already in our code. We added that in a couple of years ago. When we do, any SUP review, we look at, okay, what are the other activities in the area, and what effect do all of those together have?
Right. How many wedding venues can you have on one basin?
Yeah.
Fair enough.
And sorry, one more thought there that I think is important, because I said, you inherently can look at cumulative impacts also, but I do think that it's beneficial to call it out because you're giving the applicant a heads up at the way you may look at the issue. So you give them a chance to say, here are the surrounding land uses. Here's why you may consider these cumulative impacts, but they're not that impactful for these reasons. So you give them a chance to respond. You're not hiding the ball from them later, looking at those kind of impacts. So.
I guess it's also explicit to say that we're giving a heads up to applicants who have a progressive series of applications moving from exploration to mining, that there's the potential for cumulative impacts to be considered, and it's good to be first. Got it. Other questions, comments, feedback on the topics of redundancy and preemption? I wanted to tackle those explicitly because they were so vociferously discussed. And I can't see if anybody's raising a hand. Doesn't look like it from our online folks. Anybody here? Okay.
I guess I have one more.
Please do.
So we touched on the idea of how increasing setbacks would be coming up against that potential conflict. A couple other things were called out, including the potential for more limitations in the high country zone, and river dredging. Would you view those the same way? Can you speak to those?
So dredging I will take first, because I think that is a particular problem to prohibit a specific technique of mining. So I think this impact-based steers clear of preemption issues, but the prohibiting a certain type of mining operation is a pretty clear issue because there's case law and it's in your memo, but there's a Colorado case where Summit County said you can't do heap leach mining in any zones. That's not allowed in any of our zones, which was a de facto ban, which the court said is inherently a conflict with DRMS because they will permit that type of activity. So I do think that is an issue. And then the high country, I think what Kay was getting at earlier is you could say that there's no mining in the high country, but what you'll have to look at still on a case-by-case basis is if you have like regulatorily rendered someone's property inusable, that is perhaps why you need this exception that says that on a case-by-case basis, we may have to look at activity in other zones and make a determination that we would basically be like taking their property if we prohibit them to use it in this way. So it's like it would be a case-by-case like takings determination. So that I do think you could do, but I don't know as much as Kay on like the scale and scope of what that would look like in the high country zone.
And in the high country zone, well, first of all, I'd like to note that we are preserving the high country zone prohibition on mining for construction materials. So nobody's setting up a gravel mining operation in Ingram Basin. There's a high level of Forest Service lands. And I'm not totally sure to what extent those have been withdrawn from minerals. There are a significant number of patented mining claims that are owned by Idorado, meaning they have the mineral rights. Idorado's not actively mining in this area anymore. They're in reclamation and remediation mode. There are some individually held patented mining claims. And then also TSG owns a number of mining claims. So we have a lot of standards. It would be extremely difficult to flat out prohibit mining in that zone because of the property rights inherent with those mineral rights. So it really will be a case-by-case thing. And regarding the Forest Service lands and the federal mineral rights, the surest solution to make sure that there won't be any further any new mining claims or, mining on those lands is congressional withdrawal of those mineral rights. That's, that's a process.
Okay.
And I'm not sure how much is I'm not even sure if, to what extent there are still federal mineral rights that are available up there. I have not asked that question of anybody yet.
And in terms of the river dredging, it seemed like they were saying that that was a practice that's not permitted in the way that other mining is permitted, and that's why it could be problematic.
So yeah, dredging, there's the full on dredging where they historically they had these giant machines that literally went into the river and they churned up all the rock. And, if you're ever up around Tin Cup, up above Taylor Reservoir, you'll see a lot of the remnants, these massive piles of rock, from where they did dredging. And there's even a few historic dredges still around the state. And, it's a massive, modification of the stream course. So definitely a lot of permitting if it's a commercial level activity. There's also the hobbyist level, where people come in with, very small equipment. And, there's rules that allow the hobbyists to go ahead and, do small scale prospecting within rivers and streams. Forest Service has a really good brochure about that on their website, if you ever want to look that up. So there's again the full gamut, but when it becomes commercial, we have to go through and look at all the permitting and would they be allowed under all the various permits to dredge, and also keeping in mind impacts on water rights and all that. Dredging wasn't as much of a thing in our district back in the day. So there was, it was smaller.
Okay. Well, I wanted to tackle the two big ones first, but we also need to kind of do the crawl through the draft.
Yeah. There were also some comments from the industry side, concerns over the fact that we mentioned in here that if necessary, we can have outside consultants and that cost will be borne by the applicant. And that's already in our code. We already do that for all applications. We have notably all of our county engineers are contract engineers because, as planners, we know a little bit about engineering. There's a lot we don't know, and we know when to, stop and, when it's beyond our level of expertise. And we have the full gamut of engineering consultants that run from your, basic civil engineers to traffic engineers to full service that include mining. It can run several $1,000s in addition to our regular $1,000-ish fee. But just wanted to bring that up, that it's already in our code. We just are reiterating it.
Is there any overlap with our recently adopted grading and excavating regulations to be addressed?
Not really. Obviously, mining activities will have a significant amount of grading, but that'll be part of that application.
Okay, so we wouldn't have any reason to cross-apply the grading and excavation rules to exploration or a mining site?
No.
Okay. One of the issues that, unfortunately for the mining industry, is the historic issue of, dig and run that we all know has happened in the past. And we also know that our current regulatory environment partially designed to prevent that from happening. But that said, is there a need to tighten up the language in terms of what happens to an applicant who's granted a mining, say, permit, who goes through not necessarily bankruptcy or close down, but a change of control.
And that's why we have in our code the transfer of permit requirements, so that if they do transfer to a different operator, we then meet with that operator and through a process with the BOCC actually, and get their confirmation that they understand and agree to comply with the terms and conditions of our approval. And then we have them on record, and can proceed. And then if there's a financial security, knowing that it's properly transferred over. So yeah, we've learned our lesson from other mineral activities.
So the bond requirements are primarily focused on remediation.
Yeah.
Yeah, we changed it to restoration, just trying to have it not be as much of a term of art, but yes, yeah, that's right. For the county, that's what you're looking at, is areas outside of the DRMS permit that we shorthanded to.
I'm thinking about the mayhem that happened down in Durango with Gold King and all that. What about, what's our protection or somebody's protection if there's not a remake, not a restoration issue, but an operational disaster type issue? And I can't picture what that would be because I'm not a miner, but.
Yeah. So the Gold King mine that you mentioned is, that was a case of a historic mine without a responsible party. And the EPA had taken over the cleanup, and water quality control was part of that. So totally different layer. Than an existing operator that if they say an existing operator had a water retention pond and there was a failure. It would be on them under the many federal, state, and local regulations to do all repairs and cleanup. And
in Gold King, I would say that the activity notice is the idea that the county is at least aware of those activities. The county can have a role in like making sure it gives you more of a liaison role to make sure that EMS knows about it, to make sure neighbors know, a lot of that's already happening, but it gives you all that notice also.
Okay.
But there's not a ton more that you can do, especially about the state.
The Gold King, I appreciate this slightly off target example, but
yeah,
I'll go in for the
Lee,
visual.
I think Gold King's a really good example of why we do still want some scrutiny of legacy mine reclamation work, because even in that case, the experts, DRMS themselves, did the work and there was still an accident. And so I think when it comes to legacy mine cleanup, yes, we've lumped it in with exploration, but we do still want some scrutiny of those projects so that someone doesn't go in, do something that they think is going to be great and inadvertently create a catastrophe. So I really like that we still have some purview over the legacy mine cleanup.
Thanks. Need to pause if others have questions. I have no. Well, speaking of that, I was intrigued with the input from DISA Technologies about their new cleanup procedure. Feedback and thoughts about that? Too soon to tell?
Yeah, too soon to tell. They had reached out wondering if the regulations might limit their ability to work in this area, and our response to them was we don't see why it should.
And I wholeheartedly agree. As someone who's done remediation and reclamation work, it is very typical to go in with some kind of a plan and some kind of information for some agency somewhere. And so for for a company to come in and say, oh, we don't want to have to create a reclamation plan for you guys, that's just, that, to me, that's kind of ridiculous. There was nothing that I read in our regulation, in our code, that should preclude them from being able to do excellent work out there.
I seem to remember, I think we got those a little bit later after the second draft has come out, so I do think there's some, I do want to look more at like the bits and pieces. I think they had some really specific, that I would say wouldn't change like big picture substance where you all are headed, but, there may be some things to pull out of there. That's what I'm trying to remember. I'm like, what were those things? I do not remember, but I do remember enough that I think it's worthy of review for the next draft, but I didn't see anything, to your all's point, that changes like that general trajectory. I will point out that that there is a bill in the legislature creating a streamlined process for permitting reclamation only projects. And right now that goes through their lowest level of permitting for a mining operation also. And it would be more of a notice type application at DRMS level. And so having this one-step review, I think one of the points they were making is DRMS is headed to a notice type, a much more efficient permitting. And then you all have the one step, which I know you've already talked about a lot. So just to point that out, as I think that maybe that's where they're coming from, or that's one of the things I think a couple of commenters were saying, that's different than DRMS. So.
Okay.
That's okay.
Yeah, I think the two main things that they pointed out were the financial security requirements and economic impact assessments. They didn't want to have to do those, but the way we're drafted now, I think those are pretty minimal for the exploration and reclamation side of things.
Yeah, the changing may to shall should change that.
Shall may.
That might actually be where it came from. I don't remember now.
Could be. And another thing that I flagged from their comments that I think we're addressing here, but they requested amending section 6-301C and D to create a separate streamlined process for remediation or restoration in our language now. Only focus projects that just meet state and federal oversight standards, but per all of our explanations of having that kind of checks and balance, I think that it's pretty clear why we're doing that. So
Yeah, and in the first draft, we did have the restoration reclamation as a administrative approval, and y'all felt that it was important to have some opportunity for public information. And kind of felt like that, that was probably the best venue.
Well, and to your comment earlier, Kay, that you didn't think excavation and grading would be relevant. I can imagine small reclamation projects where they're largely doing excavation and grading. And so if we're not cross-referencing that section, it's all the more reason to have information that we want from them on stormwater management and that sort of thing. So I think what we've prepared is wholly relevant to a reclamation project.
and I did a little research on this type of remediation reclamation work, and they bring pretty big rigs in, right? So there is, even on a small project, there's a certain level of site disturbance that happens. And yeah, I guess time will tell when these applications come in, what it really looks like. Yeah.
Not two
Lena,
guys.
that's an interesting point.
It's not, it's a large flatbed with these like rigs they bring in that process the site. I apologies if I'm not using proper terminology, but it's its own kind of machine. Yes.
Okay.
So do our noise regulations that apply to mining operations also apply to reclamation, like something like that?
You do not have noise nuisance type in there right now. That's the question. I'm trying to think of if it could be covered by another one, but
I guess, what do we think about that? I mean, certainly reclamation work could be happening in or near wilderness areas.
you do have wildlife. So I think if the noise is an issue for wildlife, that would already be covered. But if the noise is an issue for neighbors and that nuisance type of noise, I'm just looking, but I do not think that is in there currently.
So the noise,
We do.
measurement factor that was raised in the comments is specific to mining operation. Did we do anything about that? We got 50 and they said 85 is normal or something.
Yeah, 85 is normal in an industrial zone. Ours is measured from, like, that's measured from a property line. Ours is measured from a structure. So if there's no structure within miles, which a lot, especially work on federal land would be, you're not even going to be triggering any of those noise issues that we flagged. So I do see where they were coming from, but I think we're looking at different measurements. So we didn't think that warranted a change.
Okay.
And so that could come in, I'm just looking at the list of standards for exploration and reclamation only. Compatibility with surrounding land uses could be where
Oh,
that
there you
comes
go.
in if necessary.
Right.
Yep.
And noise is one of our normal review standards anyway.
Yeah, well, these are in place of your normal review standards, so we do want to make sure they're covered
Right.
in here, but that's right, Kay. I think that allows you to look at noise if there is a project that has significant noise without doing a whole noise assessment. Yeah.
And
Let's see.
yeah, I can think of, several examples of where we've got, mining, remnants that are very close to residences. So.
Right, and I don't think we want to necessarily preclude the use of noisy equipment to do reclamation work, because again, the end point is a better environment, but we want to be sensitive to that too.
And it's kind of like, I mentioned the Boomerang bridge, Boomerang Road Bridge area on the river. There were very specific requirements for truck hauling through town. So, it went to, those sort of impacts. There was still a lot of trucks.
Okay. I think I caught up with, I could keep up with most of the sort of filtered through changes and redundancy, but, and I'm sure it's probably okay, or Hallie would have flagged it, but 6303, number 1, we've eliminated the stormwater management. I just want to make sure I understand where it went.
Yep. So there was a question, as to why we called out, you may submit a stormwater management plan in place of these requirements. And why we would call that out, but not call out, for the site plan, you may submit the DRMS site plan. For this plan, you may submit. And so instead of doubling down and putting it everywhere, we thought it would be clearer to take it out of there. And then at the very top of 6303 is where we added an additional statement that the applicant may submit materials from DRMS, any other state.
Didn't catch that prior reference.
Yeah, I actually think now that you're pointing that out, it should say that are submitted to DRMS and any other state or federal agencies, something like that, to also call out Water Quality Control Division.
Yeah, and Lee, I saw that it's under our section called essentially stormwater management plan. So calling out a specific plan, to me, that goes back to preemption. And I was like, well, in my head, I'm thinking we don't need them to write a stormwater management plan for us. If they've already written one that's approved by the state, they can just submit that. So again, it goes back to the discussion we had earlier. It all adds up in my head.
Yep. On the next page, we changed, it's in 6304A. We changed structures to dwelling. What we're
Where are
concerned,
you?
So,
6304A.
surface disturbance and setbacks.
Yeah.
So,
You guys want me to put it up on the screen?
yeah.
Yep.
So yeah, we changed it to dwellings, because we really don't care about somebody's hay barn. We care about the impacts to the people.
Mhm.
And so that's dwellings. It's inhabited, structures, not, somebody's tool shed or hay barn or, what have you.
There was a question from one of the commenters about having dwellings that are part of the mining operation, so a man camp or a permanent house where the miner lives. How does that get worked into something like this with setbacks?
So that's where the next sentence comes in. Setbacks may be increased or decreased during the review and evaluation of the application. So yeah, if they're saying that, under their housing impacts, the way they're gonna mitigate it is that they're gonna bring in a man camp and they're gonna locate it in this, spot on the property. It might be, and actually that setback there. So it's, number 2 above, all surface disturbance and activity shall be set back 200 feet from all property lines. And then the 200-foot setback is access and haul roads. That's dwellings. But we have that ability to modify the setbacks. And so, yeah, if they're bringing in their own man camps, we're going to evaluate where they're putting it. And, if they're putting it in a, good, safe place. And then, that's, the rest of it's kind of internal to them.
Now, what
So-
about the case of someone's house being adjacent to a county road that is being used as a haul road? Does that mean that county road can't be used as a haul road?
Maybe I should say new. The intent is new.
It's like if they're developing haul roads. Is that what you mean?
Yep.
Yes.
Okay.
Yeah, and I think somebody corrected us that haul roads are internal to the mining operation. Haul routes are our roads. So, if there's neighboring property that has a house within 200 feet of a county road, that doesn't mean that they can't use the county road as their haul road. The access or as their haul route. The access and haul roads are internal, and we'd be looking at where they're developing those.
Okay, I feel like if that's a bit of nuance that might be very specific to some mining communities, if we're gonna adopt that nuance, we should probably define it.
And we could
That's,
say
I mean,
new
that's
roads that
pretty
are
particular.
constructed for the project or something to clarify, because I
Yeah,
think
we-
that's the intent is new roads.
Yeah.
And then the
Distinction.
CMA, on this same bullet point, the CMA had a comment about, this is a regulatory take, because there's nowhere in the county where you can have a 200-foot offset and a quarter-mile offset. Do we agree with that statement?
No, we do not. We have a number of other uses and sections in our code where we have very specific setback requirements. Because
I
of
think we can all,
use.
yeah, and we can all think of properties that are at least a quarter mile from a scenic byway where mining could happen, right?
Yeah, and there is that second sentence that I do think wasn't acknowledged by several commenters that does allow for. So it's like a default would be the 200 or the quarter mile, unless the applicant can give really compelling evidence of why it should be different. And so how they can mitigate some of those impacts, like visual impacts and other, they can provide mitigation that would allow for smaller setbacks, I would say too.
Lee, I had some comments earlier in the document. I didn't want to jump in too soon. Do you want to go back to those or keep marching forward and then circle back?
Let's go ahead and go back.
Okay, let's see, what's my first comment? Going back to section 6-301I, annual report. I know I keep harping on wanting this to be more specific. The way it's written, sure, that's fine. But I do think we should specifically request any and all regulatory data that's required by either the county or by other regulatory agencies. We should request that data be reported with the annual report and in live data form. That way it's usable for either us or for someone like Sheep Mountain to really assess what's happening around a mine, and hopefully nothing negative is happening. But I certainly would like to see real data presented, not just a PDF or a JPEG or something of data.
Yeah, we talked about this. I guess I would be curious from maybe members of the public. You probably can speak to this more too, Hallie, but it seemed like a lot. The annual report, unless something is wrong, is really meant to be a check-in. And so I think that we wanted to leave it open for the county to require other things, but also not have that be an annual requirement. Maybe
Well, I
more
think it was
than some, I guess it is warranted in all cases, but I'm curious your response to that.
Hallie, anything that's reported to any of the public agencies is gonna be publicly available, right?
yes, but the timeline and the format in which it is made available to the public can be very variable. And so I think this is an opportunity, and I think this comment came from either Sheep Mountain Alliance or one of the local NGOs that specifically said, we want to see hard data. And I agree with your statement, Tori, that the annual check-in is supposed to just be an indication of like, hey, everything's copacetic. But if it's not, they're not necessarily going to tell us like, oh, by the way, we think we're contaminating the the watershed down below our property. That would be something you would see from water quality data. Or if they're having impacts to neighboring households based on air quality data, we wouldn't know that without looking at the data. And so not that the county is necessarily going to do anything with that data, but it's made publicly available in a usable format like an EDD, which is like a spreadsheet or something where you can actually touch the numbers and graph them and look at them, not just a JPEG where it's an image of text. That way it's usable for whatever entity in the region might have interest in assessing impacts from that mine.
Yeah, so the purpose of the annual report is to verify that the conditions of the approval are being met. It's not to reopen the project and reconsider unless the BOCC finds that the there's an area of concern. So, we have in here, the continued adequacy of all their plans and reports, and a satisfactory showing that the work is being conducted in conformance with all conditions of the county permit and applicable state and federal regulations. Yeah, they might, I think at some point, I think that leaves a lot of room in there for us to, be informed. I really don't want to get super detailed in our code. That's implementation as to the format that we ask for. Rather than, putting, a strong prescription in our code of what exactly that report would be.
Which restrictions we could, or requirements we would make as part of the enabling motion for the permit in the first place.
Yeah. And we always have the option that, if they give us a report and, it's like the report is, it's fine, it's all fine, everything's fine. We can come back and say, this isn't enough. Please show your work.
Since the premise of how we're writing this code is that we're asking an applicant to provide us information about how they would mitigate impacts. If there were a project where we had very specific concerns about a nearby waterway or something that would require the applicant to be monitoring that over time, to know that they were mitigating it to the degree that they told us they were. I think we could say, when we permit it, in the annual report, we expect to see this data because of this specific mitigation case in this specific case. I hear what you guys are saying, but I also understand what Hallie's saying, which is that if this is a really big project and there's potentially serious impacts that are not adequately mitigated, and we're relying on them to just like raise their hand and say like, oh, this might be a problem or not.
Mhm.
You know, there might be instances where we would want more data.
Couple of thoughts. One is we do have to fall back on the fact that enforcement is complaint driven. So if a mine is having air quality problems, I'm pretty confident we'd hear about it from anybody who happened to be downwind. I'm sensitive to the fact that we're working hard to reduce the prospect of redundancy and asking them to take data and put it into a form that they've already publicly submitted and make it easier for us to access. I'm not so sure I want to ask that.
Lee,
So I guess my
I have a
question would
question about
be,
what you just said, Lee, which is if there's not data to analyze, if it's complaint driven and there's not data to analyze, how is somebody going to know that there's an air quality problem until they're sick? Like I think that's what Haley's getting at, is that if there's information that you can track that things are changing in a negative way over a long period of time, and you can see the trends by at least if we're given, or the groups, whoever want to analyze the data, are given the data to be able to analyze the direction of the trends, then that organization can make a complaint. But if a neighbor downwind doesn't have any data, they're not going to complain until they're sick, and then it's too late. So I don't understand that approach. If there's not data to analyze, how is anybody going to know there's a problem?
Let me clarify. I'm not suggesting that we don't ask for access to the data. I'm simply saying that creating in the code an expectation that they're going to rewrite the data that they've already submitted to the state in some other form isn't what we need to do. That's all.
oh, they wouldn't,
I don't think
they,
it's about
Lee, they
rewriting
wouldn't
it.
have
I
to do
think it's about
anything different.
supplying it. I'm sorry, Haley. I don't think it's about rewriting it. I think it's about supplying it.
Exactly. So if you look at section 6-306P, we talk about, depending on what you're going to be doing, we may ask for any information that shows changes to water quality, changes to point sources, changes to erosion, changes to stormwater runoff flows. But if we don't ask for data, there's no way to quantify that. And so in the annual report, I'm not saying we need a list that we want water quality data, stream flow data, stormwater runoff data. I'm saying that we should say any data that is collected as a requirement of this or other permits shall be provided to us in a usable format. And so that data, that's what they're going to have. It comes from the laboratory as a PDF. As a PDF and as an EDD, which is a spreadsheet. All they have to do is email it to us. There's no extra effort on their part. They literally just hit forward. But I think asking for that data, whatever that data is that they're required to collect as part of the annual report, sets the expectation that we do want that data, not just to be told like, oh, we haven't affected stormwater quality.
Yeah.
Okay.
So I think that the appropriate place to do this is actually in the monitoring plan. So the structure for all the impacts is to require the applicant to show a monitoring and mitigation plan, or mitigation and monitoring. And so the idea is they're going to set up this mitigation plan, but they're not just going to give you that mitigation plan and walk away. They're going to, and those plans are going to be adopted into your permit. And so they're going to have to follow their monitoring and mitigation plans. And those may not be annual. And I do look at those as the more technical reports. And the annual report really is the short get in and out. Here's what we're doing. And then it's like C, water quality monitoring report, air quality monitoring report, because those may not all be required, of course, but it's going to be like, here's like the more detailed reports. Those things may also happen more than annually. We have for like some subdivisions and other counties required high water and low water monitoring for 5 years. And then after that, you go to every 3 years. So that's one thought, is we could go through and look at and make sure we call out usable data for those monitoring and mitigation plans in particular. So one thought.
Is the planning department like kind of urged to check in on those every time they're updated, or what's the call to action to reference those updates?
Yeah, and so we are putting everything on the applicant to propose the way that the system's gonna go. But if you want to look at 6305Q, that's the one that matches with what Hallie's talking about. I'm looking at the clean one, so I'm not sure my page numbers are going to be helpful if you have the red lines. It's page 27, but 6305Q is water quality. But the general structure matches for all of them. So at the bottom, it's got a monitoring plan that tells the key segments, what you're going to be monitoring for. So those are the key indicators. Then you establish the threshold levels. So, we're going to report every time, whatever we're monitoring for gets over X level. Locations, frequency of sampling and monitoring. So that, Hallie, is when we could, ask for data, the applicant to basically say their reporting regularity, and then the data that will be provided or something like that. You have good language, I think, there.
Is schedule for reporting.
Yes, and then the last one is schedule for reporting monitoring results to the county. So we always default to the applicant telling us what makes the most sense, and then, being able to respond and ask questions about it. But so they can say if they think it's most appropriate to sample for water quality every year for 5 years, and then we can go down to every 3 years if there's no problems. The plan is where you really get into those kind of details. But I'm curious to see, Hallie, what you think about if this would be a better place to call out the hard data requirement.
Yeah, I guess my thinking is in the annual report section, it's a broad, like 1 or 2 sentences that covers all data. If we put it in here, that's fine. But then I would think we would also need to have that same statement under like any kind of air quality, any kind of noise monitoring that they're required to do. I mean, it becomes a little more repetitive, maybe.
Yeah, you would definitely repeat it.
Yeah, but I absolutely see what you're saying. I think what I'm implying is like a just broad prescriptive statement that says, give us all your data, as opposed to putting the burden on the permit writers and the applicant to say, it requires more nuance, and it requires I think the planning commission or the planning department staff to be really on their game to make sure that they catch everything. I've heard a few things today that's like, oh, we'll do that at permitting. Well, you got to make sure you do it then at permitting, and that not that you wouldn't, but there's just a lot to remember.
I think the language that we have in 6301I, item 2, under the requirements of the annual report certainly for mining operations, a satisfactory showing that the work is being conducted in conformance with all conditions of the county permit and applicable state and federal regulations. That's about as broad as it gets, don't you think? Showing being defined by whatever requirements or expectations are put forth in the application and SUP.
Maybe there's a different tack we could take, which is to add in to the mitigation plan, something that says like, as data is provided over time to the county, it will be noticed publicly and made available. Because if we're relying on a complaint-driven system, I do think there needs to be some transparency about the data that's provided without making it more onerous and they have to provide it more often or whatever. But just like if we could notice to the public, or people have signed up and said they're interested in the project or something, like we received this new data.
Mm-hmm.
Yeah, so we've got 2 different things going on. We've got if something goes wrong or somebody thinks something's going wrong and there's a complaint, then we have the whole evaluation, research, possibly enforcement side of things. this is the annual report advising us of how things are going, absent a complaint. So we've got, we've got both, and, the annual report, because that happened, when we, if necessary, we can take it to the board. If people are interested, they can ask for it. If there's, nothing that we have to take to the board. I think you guys are getting into what we call implementation, and we don't necessarily put that sort of stuff in the code. That's an internal policy and procedure thing. So, if you put it in the code, it could actually work against you. And so we can, on this annual report, we can put in something about, including submitting, we say, the monitor, submit the monitoring reports. As somebody who's seen more than my share of those sorts of reports, I prefer the summary. I want the executive summary of what that report means. But, we can clarify a bit.
Maybe we could say something like the adequacy of required. Hold on, I'm gonna screen share just so you guys can see where we are, but we're still in the annual report, but the continued adequacy of the plan studies and reports is meant to, is this working? Which means, is your monitoring plan uncovering any problems? That is the idea there. So we could put something that calls it out to the, as a reminder, like you're saying, Hallie, even though it might not always be appropriate, we could say including underlying data as appropriate or something like that, where, the staff, everyone's on notice that may include the underlying data, but it's also not requiring it every time.
That work. Thanks.
Yeah, I mean, I'm definitely sensing pushback at requesting data, and certainly in my world, without data, you have nothing. So I still feel like we should be asking for the data. Whatever that data is, it might be nothing if there's no data requirement as part of their permit. But yeah, I just, without data, you don't know if a uranium mine at the West End has any impact on Telluride. Maybe it doesn't, but without any kind of air quality data, you can't say yes or no. So that's why I feel like data is like king, but I'm also an engineer.
And as a matter of practice, you generally, when you get an annual report from an FCP owner, you have an agenda item or a reporting item in your section of a meeting. So there's a mechanism by which to make those reports more public.
And sometimes we will actually put them on an agenda for review by, the planning commission and then the BOCC. And a lot of it also goes into, depends on what we put in the resolution. Sometimes we'll specifically say that the annual reports must be reviewed by the decision-making bodies.
Which would then give us public access to contribute with proper notice and all that.
Yes.
Okay. All right. What else you got, Hallie?
That was one of my big ones. Let's see. Another one was on the definition of legacy mine. This is under definitions. I don't know what section that is. I'm in the red line version on page 9 of the red line PDF. Let's see. This is section 6-301K, definitions, legacy mine. The second half of that sentence gave me pause. So a legacy mine is a mine where pre-law mining operations have occurred or the mining operations have been abandoned and no bond or other financial assurance or reclamation responsibility exists. I don't know where the definition came from, but I've worked on brownfields and CERCLA and reclamation projects where in tangent with an EPA cleanup, there's also legal proceedings against a potentially responsible party. And so if we're saying that only the cleanups can only happen if there's not a potentially responsible party, to me, that means that some sites might not be able to be cleaned up because there could still be a potentially responsible party. And in the course of sell-offs and buy-ups and blah, 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 you just kind of lose track of who that PRP is, and it can take years to find them. But in the meantime, if the latest property owner wants to clean up their site, we should let them. I don't know. What are your thoughts on that, Tori?
Yeah, so this definition was added to the legislation, so it would become a new definition for DRMS. So borrowing from DRMS, I had not thought about that fully otherwise. So that's something we could look into more. I think if it's not a legacy mine, so if you're doing the cleanup of a legacy mine, that puts you into the category of a reclamation only permit. I think all that means is if you're not sure, it would put you into a mining operation and you would do a 2-step review instead of a 1-step review. So it's not that couldn't take place. But it would be, you know, a more onerous application for sure. So they could still do the cleanup. But I haven't thought about that before, and I think I would need to do a little more research.
Perhaps some language about ownership being contested. Ownership responsibility being contested.
Mm-hmm. Yeah, and
Yeah, I almost wonder if
definition also could, I mean, when we can, we default to DRMS. When we need to, we can change it. So we don't have to by any means. The bill, I mean, the original introduced bill didn't have a definition at all. They added a definition and I think cleaned up a mistake that didn't even talk about legacy mining for the actual permit. So they just had a problem with the bill there. But anyway, the bill has only made it through one committee in the legislature. So we'll also definitely be keeping an eye on this definition, and we can talk to DRMS too about if they're seeing any changes to their own definition and look into this contested PRP.
I think you give a good example, Hallie, where you want to make that possible.
Yeah, I do think the intent is not to be overly narrow, so.
Yeah, most of my examples are confidential, unfortunately, but it's where, I mean, it happens with Circle. It's actually happening over in where the Gold King mine was, Silverton right now, where is it Sunnyside is potentially responsible for some of the cleanup that EPA is currently undertaking. They're still in litigation trying to sort out what Sunnyside may or may not be responsible for. But in the meantime, EPA is doing the cleanup and they might just back charge them. I can imagine a scenario here where there's an adit on your property. You just want to clean it up, but you may have a claim against one of the giant mining corporations or oil and gas companies that owned it over the year, and you might be able to still pursue that claim. And so I almost wonder if just changing the last word instead of exists to, no bond or other financial assurance is available or is currently known or something like that.
Yeah. Well, actually, now that I pulled back and I'm reading this, I think that the point is that and I don't think in your example, there's no existing bond or financial assurance.
Right.
So
or
in this
reclamation
case,
responsibility.
So if it's contested, then it may still be a legacy mine because there's none of those things exist. If it's contested, they don't exist, and it could be considered a legacy mine.
Right, but does that mean that I have to do 15 years of legal research before I can clean up my adit to make sure that no one exists that could be responsible?
Well, first of all, we could put some language in here that's when DRMS is determined or something like that. I mean, I don't think that the county should be determining this separately than DRMS even.
Yeah, our regulations as we've written them, they don't get to the level of defining whether or not actions are related to a legacy mine. So I think we're good.
Well, the reclamation only permit is for a legacy mine.
Yeah.
So that's all we're talking about is if you fall into the category of reclamation only permit or mining operation.
Yep. And really, I just don't want to preclude someone who may have a very real claim to file a lawsuit against another entity, or I don't want to take that away from them by them doing this cleanup under our code that says, oh, it's a legacy mine and there's no reclamation responsibility in place. I don't want a future lawyer to be able to point to that and say, see, they don't think that my business is responsible for the cleanup, blah, blah, blah. So maybe I'm overblowing the risk there, but I just don't want to take away someone's right to sue a corporation for a cleanup that they did on their own land.
Yeah, I'm not seeing how this definition would change that.
Okay.
I do want to
Great.
think about it more. Another thing that the DRMS comment on that I don't think it's like substantive to bring up here, but I do think that they had requested that there's a couple of places that we clarify that, our determination has nothing to do with DRMS's determination. So an approval by the county does not mean you're approved, does not mean you can transfer the project without DRMS approval. And I mean, we could have some very blanket language up here in these general provisions that says something like this, that there's no other none of these regulations are intended to change anything, and I don't think they would. Nothing would stop an attorney from arguing something like that if they wanted to, but we could put some general provision that just says it's not.
Okay.
We're not changing, because I'd already been thinking about doing that for DRMS, we're not in any way affecting existing DRMS regulations, federal requirements, blah, blah. Yeah.
Okay.
Applicability, and 301B has some kind of general language like that we could add to.
Okay, but you're taking this as a note to explore further.
Yeah.
Ally?
Okay, then right below legacy mine under mineral, there's a sentence in there on the 5th line. For the purposes of this article, this definition does not include surface or subsurface water that is regulated by the Colorado Division of Water Resources. How does that affect something like the commercial dredging that Kay was discussing, or pumping water to a settling pond, for like salt extraction, which has been discussed over in Paradox Valley? What's our intent with that sentence? Because you can do mineral recovery from surface and subsurface waters.
I mean, for the brine example that came up earlier, we were looking that we're not sure, we don't think that would actually fit in mining operation anyway. Trying to remember that conversation, Kay.
I was just in a
Yeah,
web water rights the other day, and I'm trying to remember what they told us.
You could look to New Mexico or Utah for how they manage that, because they're giant salt flat mineral recovery sites in both of those states.
Aren't those water sources regulated by the respective water resource divisions?
That's right, DRMS doesn't regulate them either, so that's part of it, is matching with what DRMS does, and they consider a mining operation.
My take on it was the purpose for this insertion was to avoid suggesting that we're preempting water resources.
Right.
Yeah.
Water in and of itself is not a thing that we're considering mining.
Not under these regulations.
Mhm.
That wouldn't be a mining operation.
Okay. So if Paradox, I think where I'm thinking is Montrose County, but there was a proposal for, or an evaluation at one point for the Department of Reclamation, I think, to pump groundwater into settling ponds and then recover the minerals, which would be, big bulldozers digging up the minerals and then selling them for profit. That's not considered mining.
Well, that doesn't fall under the surface or subsurface water regulated by the Colorado Division of Water Resources. So, talking about wells, and whether it's groundwater or subsurface water, like in aquifers and such, that's the difference.
Yeah, some of your examples, Hallie, I think I guess I need more information, and I don't know if it would be better not offline, but I mean, I do mean offline because you can give me more details of it, but I'm not, if this sentence needs more work, I'm happy to look at it. I'm
Yeah,
not
I
sure
can
the
send-
wordsmith it. But
Yeah, I
great.
can send you some information on what I'm imagining and whether or not we think
Yeah.
that that should or should not be included. I mean, maybe the answer is
Yeah.
no, we don't want that under here. Then I guess
I'm
the next
happy to
question would
jump
be,
on the phone and talk about it too. I'm not sure that I'm gonna get there in my understanding of what you're asking very well in this format.
Okay.
And I will say, I guess that, I mean, whether we bring it back at a planning commission meeting, we could send it out. We could do some sort of, if we're, changing some of these things, we could do like a memo in between too. I don't know that would, if that rises to like needing another work session for, but we can wordsmith this, I think.
Yeah.
But yeah, I definitely would like to hear more. I think when I can like look up the regulation too. I don't have it right
Hallie,
next to me.
not to wrap you up or cut you off, but we're at what I wanted to have as a break moment. So
do
we'll
it.
come back to you. We'll break for 5. Short recess. We'll be back at 11:38. Thanks.
I don't remember if I got that. That's really fast. Yeah.
We good? As I was saying to the crowd here, we have still more commission questions and feedback, but we want to recognize the fortitude of those from the public who would like to speak. And since this is a work session, we're going to put a pause in the commission and commissioners' comments and move to the public comment period so that we can take in some input from the public, questions and so forth. So ground rules are, do we have a microphone? They're going to be able to.
Should I move this? We got it. Thanks.
Alternate between any online comments or commenters and anybody here in the room. And we'd like you to hold it to 3 minutes as best you can. I'll wave at you when your time's coming up. And obviously, we expect your questions and comments to be directed at the current content. And in terms of questions, although this is a work session, we're always careful about creating a dialogue that takes us off. So we would ask that if you have questions about the application, I'm sorry, not application, about the code, or ask them to us, and then we'll address all the questions at the end of the public comment period, unless there's some need to go online and help. So that said, I don't have any raised hands online yet. So who would like to speak from in-house?
Go ahead.
Please do. And of course, introduce yourself to the record.
My name is Bob Larson, and as I think you know, I live in Uray. I'm a mining and geological consultant, but I have business in San Miguel County. I have myself mineral properties in San Miguel County. So all of this is very personal to me because I have operations going on over there. So backing up just a second, in the 1990s, I was on the Planning Commission in Uray County, was later elected as a commissioner. And so I've served in that position. So I understand a little bit about what goes on with all of this. And I want to share with you one of the first things I learned as a commissioner through Colorado counties, through visits with the governor and legislators, is that we as a county were just one entity within the state. And we needed to be aware of and comply with all state rules, regulations, and statutes because that was our responsibility. We weren't an entity of our own. We couldn't just go out and do whatever we wanted to do, but we needed to comply with what was in place and what was being done. So that being said, I'm still concerned about duplication. I'm concerned about preemption and how you're going about adopting all of this and what your responsibilities are as a planning commission and as county commissioners. I think that's a very important thing to look at. Now, if we look back at the CMA versus Summit County case that went on a few years back, and it specifically says a county regulation may be invalid if it conflicts with or is preempted by state law. So I am still concerned about what you're trying to do here. It does give you the authority, and it states that information not already included in a permitting system may be required by the county. So what are those items that you're concerned about that are above and beyond? I don't think you've defined what items that you need to be dealing with. 90% of what you're asking for and doing in this proposed regulation is a duplication. You need to go beyond that and find out what it is that you're really concerned about, what you want to see done that's not being done. Because you're not going to be able to change what the state's doing, what the federal government's doing, as you've mentioned today. So that's very important for you to know. It says counties, on the other hand, have no constitutional source of power or authority, are creatures of the statute, and derive their powers or authority and regulate from state statutes. So you again are part of that state of Colorado. You're not the entity yourself individually here on some of these. So the final statement of the judge says, in my view, that which the General Assembly specifically permits, even encourages, and with respect to which it authorizes an agency of the state to regulate, cannot be regulated, much less prohibited, under the rubrics of a planning and zoning regulation. So I'm concerned again about the fact that in your development code for San Miguel County, you talk about encouraging mining in the west end. Well, this is not encouraging mining. This is discouraging mining, as I mentioned in my notes that I sent in. Let's look at those things that you really need to be concerned about for San Miguel County that's not being done. And let's develop that and let's work on those. Now, see, I've worked with the DRMS since they first put in their regulations back in 1976. I graduated from the Colorado School of Mines in '68, so I've worked with them and been giving them data and doing applications since then, so I understand that. And you're taking this a step beyond all of this. I think you need to rethink about what you are doing here. I think it's a serious step. If I were in your shoes right now as a planning commission member or as a county commissioner, I would be concerned about where is this taking San Miguel County? What is this going to cost my county here? What's it going to cost our taxpayers to follow through with this when we can realize we're duplicating, we're preempting. These things are going to be changed, and a lot of this you're not going to be able to do down the road because it's going to be challenged. So think about what you're doing. Don't rush through this. Do more background research, understanding where all this is coming from, and make sure what you're doing complies with what the state of Colorado is doing and what they need to have done. Thank you for the time.
Okay, so we appreciate your experience. Okay, any hands raised online? And I would certainly invite the county commissioners who are online if they wish to. Paul, I won't attempt to damage your last name, Paul. I think you have your hand up, or is that my mouse? Oh, that's my mouse. Sorry. Paul's like, wait, what? Okay, well, I don't have anybody online just yet, but I have a group of 4 in the back there. It looks pretty interesting. Who would like to speak?
I don't have any comments, but I think we've provided.
You would identify yourself?
Yeah.
Thank you.
Hi, everyone. Dan Ben Horan, Bureau of Land Management, Uncompahgre Field Office Manager. We've already provided the commission with plenty of comments, and we appreciate you incorporating and addressing and considering those comments. Just want to show appreciation for us allowing the entire team here and everyone online to be a part of this process. And yeah, looking forward to continuing working with you all. That's all. Nothing specific right now.
We're thrilled to see faces instead of paper.
It worked out. We happened to be in Norwood today for a site visit. So yeah, glad to be here.
Thanks for being here.
Okay, I now see that Paul has raised.
Right.
Paul, please proceed.
Okay, I felt obligated to raise my hand. But a couple of things I'd like to add for your consideration. Because I think it's important when you make these decisions, you have the best information available. If you'll bear with me, I'm going to read right from the EPA's website of today. And it's their emergency response to the August 2015 release from Gold King Mine. On August 5th, 2015, EPA was conducting an investigation of the Gold King Mine near Silverton, Colorado, to assess the ongoing water releases from the mine, treat mine water, and assess the feasibility of further mine remediation. While excavating above the old adit, pressurized water began to leak above the mine tunnel, spilling about 3 million gallons of water stored behind the collapsed material into Cement Creek, a tributary of the Animas River. EPA takes responsibility for the Gold King mine release and is committed to continue working hand in hand with the impacted local governments, states, and tribes. So EPA has taken responsibility for this. You mentioned concerns about the mining community throwing the keys and walking away, or there not being responsible parties under CERCLA. Those things were true, but have largely been addressed by DRMS and the BLM and by our federal government through the process of changing our laws. So legacy mines are generally, you're going to find pre-1976. The other issue about throwing the keys, I think you should check with the DRMS, who works under a memorandum of understanding with the BLM. And I think our state treasurer has around $750 million, mostly in cash, that's just there to prevent people from throwing the keys and walking away. So if those are the reasons you're really going through this process, perhaps you're putting more effort into it than is really required to achieve your aims. I think everybody should be for sustainable mining, and I'll echo some of Bob Larson's comments. We ought to be focused on what gives you the biggest bang for your buck. And with that, I appreciate the opportunity, and please feel free to call on me again.
Okay, will do, Paul. Thank you for your comments. Okay. Anyone else in-house? Guess you guys are all together, right? Okay, got it. All right, Mr. Reams.
Okay, there I've got unmuted. Oh,
There you go.
yeah. Okay, my name's John Reams. I live in Natarita, and I'm the president of the Western Small Miners Association. We have members from Colorado, Nevada, Utah, and New Mexico, so it's not just in this community here. But what I'd like to bring up is I liked what Bob earlier was saying about duplication, because we have a problem with, if we got to do a report, send it to you and then send it to state, we'd like to only do it once and go through one thing, one time. So I'd encourage you to not duplicate if you can help it. I understand. Basically, I agree with what Bob Larson had said, and I won't say much more because I don't want to repeat. So thank you.
All right, thank you, sir. And we appreciate the written comments and the thought behind that you submitted as well.
Okay, thanks.
Mr. Ekman. Are you unmuted and ready? Mr. Ekman? This doesn't happen very often.
No, he's muted again. No, wait, that's me, that's me.
Going on and off, probably trying to work. but
Yeah.
Here.
Hmm. Well, can we leave this mic on in case he gets it working for him? He's muted again. And unfortunately, I don't have anybody else in the queue from the public as far as I can see. Is there a second? Oh, yeah, there is. Hold on. Sure. Okay. Well, let's do this. Mr. Ekman, when you get your sound figured out, please do speak up. In the meantime, we'll do a blended hybrid conversation and open the floor back up to the commissioners from both commissions for any further questions or points. So Hallie, I believe you had the floor when last we spoke.
I'm happy to keep cranking through my comments, but I certainly don't want to take time away from other commissioners who might have something to say too. So don't let me run away with this train.
Well, you know, you bring a certain expertise to the question, so your input is certainly valuable.
Thank you.
Maybe if we can differentiate between, and Robin, I see your hand too, so I'm going to let you bump ahead of Hallie here just a sec. If you can filter things we need to discuss versus things you want to just recommend.
Sure.
Then, you know, since we're still in work and draft form, we can have other opportunities to discuss those if we need to. Robin?
Thank you. Yes, I'd like to address Bob and Paul's comments. Am I misunderstanding that the document that we're writing is it's not necessarily asking for duplication of what's already required. It's asking for us as a governing body to be looking at these things in the applications that are submitted to DRMS and other, you know, EPA or whoever preempts us as a county, that we're asking for that same information to be shared with us. And then internally, we have this mining document that guides us as a body to make sure that these things are being covered, are being looked at in these other requirements, and then guides us to ask for more information on something. And I think that, Mr. Larson, that's what you were saying, is that what are we concerned about above and beyond or behind the existing regulations that mining applications and permits are already subject to? What are we concerned about as a county? And I'm viewing this very extensive, and maybe I'm wrong or naive to this, but that this very extensive document is guiding San Miguel County as to the things that we want to make sure are being looked at. And then, Bob, I was a little confused because you directed us to be focused on what we're concerned about above, behind, and beyond the existing regulations. But then at the end of your statement, you said you expressed concern that we're going beyond the existing requirements. So I'm a little confused that if you're asking us to only be focused on the things that are beyond and behind, but then you're concerned that we're going beyond and behind. So what kind of direction do you have for us in that contradiction?
Oh, yeah, thanks.
Yeah, I think since we're having a conversation, go ahead.
Thank you.
If what you are asking in what you're calling your permitting regulations, if all you're asking is to share this so that you can review it and be aware of that, that's fantastic. But if you're looking at all this information for you to grant approval to it, or saying that you now have the permit from San Miguel County, that's a whole different thing than sharing. So are we creating permits that have to be approved by San Miguel County, or are we informing you of what's being done and how? I mean, those are two very different things.
My sense is that we have differing approaches to how we skin this cat. What I'm hearing from you, Mr. Larson, and from Paul and from John Reams, is the suggestion that our regulations should identify the things beyond what you're already being required to submit as being, this is what San Miguel County needs. In addition to, and assuredly under reasonable expectations. Whereas the county's approach has been to say, this is the list of things that need to be covered, and we'll accept any federal, state, or other agency submission as fulfillment of those expectations. We don't want anybody to have to redo what is in a DREAMS application. I mean, having read those, they're very educational, but I wouldn't want to have to write one. So I think what we have here is kind of a difference of approach. And my earlier point about what happens if one of those agencies whose evaluation we're counting on steps away from that responsibility is a concern for us. So that we make sure that, okay, if the EPA doesn't ask for X, Y, and Z, but we still think it's important, it's still in our code, we would take it from the EPA if they had it, but if they don't have it, then we'll need it from the applicant. Is that a fair summary?
Yeah, and as I said in my presentation, we've been saying throughout, we recognize that there is the federal and state purview on their permits, but we're looking at how this impacts county interests. Excuse me. So, for example, we've had a number of exploration permits, and a couple of things that come out of those. One, what are the impacts to our county roads? What are we doing for vegetation and weed management? Because we want to ensure that there's not a proliferation of noxious weeds that can spread farther. And we typically want to know where water being used is coming from, because that is a rare or a limited resource on the western slope. So we're accepting for example, the revegetation plan that's coming from the BLM and saying, okay, yep, you've got your approved revegetation plan, we accept that. But then we put conditions on that are related to the county issues. So, it's a very complex, layered process. And it is important for applicants to explain how they're dealing with county concerns, in addition to those that are covered in the federal and state permits. And then, for us, when we come back and review our various standards, looking at how those are met, but also understanding at where we can go. So it's going to be quite nuanced. It's not an easy, simple, cut and dried thing. If it was, it'd be a checklist with administrative approval.
I very much appreciate what you're saying there, and you're adding those things that weren't included in the other permitting process. So can you simply state, we need to have copies of all of the permits that are being implemented, have been being approved, and In addition to that, we want this, this, and this. I mean, in very simple, see, your 55-page original document duplicates everything else that everyone else has done. And the way you wrote that was, we're the regulating agency and we have to have all of this data. Well, you're coming back to the fact, and I appreciate that totally, of saying we're accepting what the DRMS is doing. We're accepting what the Forest Service does or the BLM. That can be taken care of in a paragraph or a sentence, that you accept that you just need to be informed, but leave all the rest of that stuff to them to require, instead of you having every item listed there. List the items that you need, the road concerns, the vegetation concerns. You realize that stormwater is taken care of by the state. You realize that all of these other things are being done by these agencies. Accept that and move on to what you need to be concerned about.
Well, certainly in the first draft, I can well understand where the concern came from. I think we've attempted to insert the language that clarifies that exactly that the federal other reports are accepted as fulfillment of our regulations. And what I'm hearing is that we don't have it clear enough yet. I don't know how we fix that per se, but perhaps there's something we can do in the general provisions to clarify that.
Can you even say that in your purpose? Make a good
That's what I'm
paragraph
thinking.
at the very beginning that explains that. So when I come in and get your documents to see what I need to have in an application, I can feel, okay, I need, they're taking my DRMS stuff and all of this, letting me know that on the front end. And, they've got concerns here that I need to deal with separately. And I can do that. I can go about it in that way.
Okay.
But I'm not starting from ground zero again and recreating.
No, I think it's our job to make sure that it's clear.
Thank you.
That's not the
Good.
expectation.
Good.
We can, that certainly helps a lot. I also had a question. There was an element in here. One of the suggestions from one of the comments was, and it might even have been yours, about a way to identify a checklist of where things are in the process. And I flagged that to ask isn't that part of our new system?
That's implementation. That's not code.
I understand.
So we have our online permitting system where we, can set up a list of everything that has to be submitted. We can even create forms. I just applied for a building permit and there's a construction mitigation form that I had to fill out and, explain, what, if I got a porta potty, where was it going to be? If I got a dumpster, where was it going to be? All those various things. If we determine that it's necessary, we can create that. We're not there yet.
Understood. But we now have the capability to offer something along those lines.
We've always had the capabilities, just now that it's in our
better.
electronic portal.
Right. Yeah. Okay.
In the past, we had paper checklists.
Okay. All right. Okay. Thank you, sir. Appreciate that. Hallie? Robin, did you get your answer?
Thank you.
Yep, I think I've been looking through the rest of my comments. I can just email them over to Kay and Tori. They're mostly minor, but to kind of sum up the rest of my comments, they're largely in response to the comments we got from the Colorado Mining Association, and somewhat DRMS and BLM. I think I really want to be sensitive to some of their concerns about, for example, requiring applications to be certified by a professional engineer. It seems to me like a certified geologist might, or a professional geologist might do. And I'm thinking in particular about the mining application we approved last month that was prepared by county administration officials, certainly not by an engineer. I think also there's some comments in there about our language around highways and haul routes and avoiding commercial and residential areas. Well, some of our highways go right through downtown Norwood, for example. So I think being a little more specific in what we're actually trying to achieve, as opposed to the measures of our criteria there. I just want to make sure that we're not just kind of steamrolling the mining association's comments. I think there's some good stuff in there that we should be sensitive to. So I know we're not planning to do a point-by-point response to comments for all of those agencies and the CMA. But I do think we should make sure we go through them point by point on our own and give attention to some of those comments.
Okay, is there a form of Hallie's comments that it would be appropriate to circulate as she submits them to you as well? Or does she need to give them to you and we see them in the next draft or not?
So.
I mean, I can CC the planning commission. That's easy enough.
Yeah, I just don't want to run afoul of
Yeah, this is,
sunshine laws.
yeah, this is a legislative action, so yeah, certainly they can be copied. We don't typically include planning commission comments in our review comments. Those are more of a working internal document in our mind, but yeah.
I guess specifically what I'm suggesting is that rather than point them just to you guys, that Hallie copy us on her concerns so that we can have those in mind for our next conversation. Because clearly we're going to have another one. Some sort.
Yeah. I mean,
That's okay. All right.
Hallie, if you, either send them directly to me and I can forward them, or if you copy everybody, please BCC things, because that's especially for the Board of County Commissioners.
I'll
And
just
that
send
way
it to you and let you distribute it then. I think that's probably the safer way to make sure it goes out appropriately.
Yeah, we want to avoid having a serial meeting via email.
Right.
Exactly. Yeah.
Cereal. I'm hungry. Okay.
But I think I think most of my comments are not worth discussing here, other than that. The other thing I was going to say is in terms of a crossroad or a crosswalk, the CMA actually provided a really great crosswalk in their comments, basically showing how absolutely everything we're asking for is in their documentation, maybe not to the same level. So we might request more on noise, for example. The one and only thing that they didn't seem to think was in a DRMS application was lighting. So I really feel like we're striking the right note in terms of asking for information. We'll apply mitigations to our permit approval side of things, but we're not really going above and beyond what DRMS already asks for in most cases. I mean, the CMA in their own comments made that pretty apparent.
Yeah, that was an extensive crosswalk.
That was awesome. And thank you guys. I mean, you did some work for us, so thank you.
Right. Okay, Mr. Ekman, you want to try again?
Can you hear me now?
There we go.
Oh my gosh, we got it working. It said that it's no doubt user error on my end, but it said that the host was not allowing, it was disabled by the host, but for whatever reason, we were able to get past that with my most recent effort. So thank you guys again for allowing us to participate in this process and for today's work session. I also appreciate what sounds to be some tweaking, at least around the edges. Earlier in the call, there was some discussion about our concerns regarding the alternatives analysis that we had some issues with, and it sounds like you guys are making some changes there. So we're very grateful for that. I recognize the irony of duplication here with some of my previous colleagues who've spoken in the room, but I just want to reiterate some of the comments from Bob and Paul and John on concerns about this, really from the top line, sort of wondering what the impetus is for doing this right now. And now we saw, in recent articles in the local papers, some of the reasons that were offered for this. One of them was that there was an uptick in mining exploration applications. I'm not sure that there is a great deal of activity there that would really justify a 50-page overhaul of the regulations. One comment said that the county would like to streamline its mining regulations, which was puzzling to me, given that you have a one-page regulatory framework right now and are moving to a significantly more complicated one. And the others seem to sort of center around an idea that was mentioned earlier in the meeting, and that is the goal of mitigating impacts from development of and mineral exploration, rather than determining whether or not it can happen. And I appreciate that. But I think what a lot of our members are looking at is that in the course of evaluating whether mitigation efforts are adequate, whether that county permitting process will affect a stop on a mining project and end up making that determination anyway. For example, let's see, one of the, trying to just sort of cover, there's so many provisions, and I recognize that our crosswalk gets into this in great detail. And I'm glad you guys were able to take a look at it, but I know we don't have time to get into every provision that CMA highlighted in our comments. But a general theme here seems to be that the county is trying to do what I think could be summarized as going above and beyond what DRMS is doing in a way that we view as still triggering preemption issues. Like the most recent draft of the regulations includes the term restoration, which purports to include reclamation of areas outside the DRMS reclamation plan permit area. But the problem with that is that it includes surface disturbance as a part of that. But affected land under the DRMS mining rules already includes surface disturbance. So I struggle to see what the regulations cover that isn't already covered, or that it doesn't exist. In other words, I don't believe that there's any surface disturbance occurring that wouldn't fall under DRMS's definition of affected land and therefore be included within their permit and therefore preempt San Miguel County from regulating in this area. So that's sort of an overview focusing on one specific definition of sort of the structural issues and concerns that we have with this. But we certainly appreciate the effort that you guys are undertaking to make sure that mining is, responsibly regulated in the county. I'll leave it at that because I know we could be here all day if we went through all of CMA's points, but I appreciate the opportunity.
All right, thank you, sir. Appreciate that perspective and your extensive comments. As Hallie said, there's quite a bit of detail in that cross table. Other comments, questions?
I do have a question.
Yes, ma'am, please.
I'm Kathy Cooper. I'm the Executive Secretary of Western Small Miners
Would you mind just coming up?
We need you for the record. You can just come up here. Oh, there you go.
I am just wondering if San Miguel County is going to put these regulations on, say, your timber industry, or your ski industry, or your housing industry. Why is the mining industry being signaled out?
You want to take that one?
So we have separate regulations for logging, and we will be updating those. We have separate regulations for solar. We have separate regulations for oil and gas. We actually have regulations in our code for ski areas, for golf courses, for any number of uses. So our direction, as I said at the start, the Board of County Commissioners wanted these updated. They asked me to do it 6 years ago. It's taken us this long. Because they felt like what we had in our code was not, clear enough. We've got, varying levels of attention to all these different uses, but they are covered, and we'll be putting all, updating other regulations as we move forward. We're making this right now, the regulations we have, we've got one page of mining, but then we have to look at a lot of different sections of our code and pull them all together, which is very complex and requires, quite frankly, a lot of interpretation. So this actually, by providing some very, what could be seen as a lengthy but very specific list, is actually to me, clearer. We're not having to explain to people what this means and why. And, we already did that for solar. So we'll, move on and do the other activities and uses as well.
Yeah, I would encourage you, if you want to take a look at solar, there's actually, the format matches. There's some, things specific for mining or solar, but, I would encourage you, it gives you a sense, and I know the page numbers are really daunting. I think solar is about the same amount of pages also. And I made this point in our memo, but for us, the scope of work was natural resources, and working inside of the existing land use code would have been like many hundreds of pages of red lines, and it just didn't seem feasible. So that's part of our effort to take out natural resources, that it's hard to see the background of why we did it that way. But it was hard to work within the existing land use code was part of it too. Yeah.
Okay.
Lance had his.
There's an exhibit in our packet of the code changes that we'll need to contemplate to basically retrieve all these parts and pieces that pertain to mining and bring them in. And that's a 9-page document in and of itself.
And sadly, this was the
Just changes.
cleanest, clearest way we could figure out how to
Well, I
do it.
think it's fine, but it's not visible.
Right,
That's good.
yeah, no, that's right.
Commissioner Waring.
Thank you, Lee. I wanted to try to respond to both Adam and Kathy as one of the commissioners who did request Kay to embark on this 6 years ago, and try to tie together some of Adam's comments about the concerns he had about why we're bothering. To start with, the uptick in exploration is real. And in my mind, although I'm not an expert, when you go exploring for something, it usually means that you've got a notion that what you're looking for is present at some level. And so my desire here is to get ahead of potential mining development, mining operations, by having updated regulations that reflect the changes in our county, both demographically and also, well, for the most part, demographically. An example of that would be perhaps in the 70s, 80s, housing was not such a concern. At this point, housing is considered a crisis by many, and if there were to be a large mining operation that were to open in the West End, housing would be a county concern that would want to be discussed during that process. Another point that you made was an effort to streamline, and I thought that Tori did a pretty good job of explaining that while there's more pages involved in this section of a new code, it is an effort to streamline the application process by not having to research the entire land use code in order to make an application. So it's a perhaps longer chunk of pages up front, but a lot less effort at the end in order to go through the mining application process. The final point that she made was about our efforts to mitigate. And I think that this is really important because we as the county have no ability to say there should be no mining in San Miguel County or there should be any mine that wants to come in, doors are wide open. And what we are responsible for, what I am responsible for as a commissioner, is the health, safety, and welfare of the citizens of the county. And what I worry about is some of the things that are specifically called out regarding noise, regarding dust, regarding county roads and haul routes, and revegetation, etc., water. All those things are important to all of my citizens, and I need to make sure that a new operation doesn't have a negative effect upon the existing citizenry. I hope that helps explain a little bit of the thinking behind this process and perhaps a better understanding of why it may seem daunting on its face, but in reality, this rewrite, if you will, this upgrade is hopefully going to be a streamlining process at the end of the day. Thank you.
Sir, it's good to have that backstory. Any other comments or questions? All right, do we need to take a definitive action at this point in terms of next meeting?
So we've been listening and we've been taking notes on, further changes we need to make to the draft. I haven't heard anything from you guys that is super substantive. It's more clarifying. So my question to you at this point is, are you ready to take this to the public hearing level? Which we would prepare one more draft, at least one more. Publish it, send it out to all of our stakeholders and review agencies with a minimum of 21 days review period, schedule our meetings. So we're looking at, probably May at the earliest for planning commission review and recommendation to the board. And then following that, June to July, having a BOCC hearing. Like I said, I'm not hearing really substantive changes, so I'm not sure that another work session is warranted. And that's what I need to hear from you guys as to how you feel about that.
Chairperson Brown, do you have an opinion on whether the county commissioners would like to continue working on this or turn it over to us to tackle the draft?
Thank you for the opportunity. I would obviously like to hear from Commissioner Gleason and Commissioner Waring, but it feels to me like you guys have got it and are doing a wonderful job really digging into the details, listening to public comment. So I feel very comfortable leaving this to you. Lance and Galena, do you feel differently?
No, I don't feel differently. And I agree with what Kay is saying, is that nothing I've heard today has been very substantive in the change in regulations or something that would necessitate another work session. So I would also, hear what Commissioner Waring has to say, and then would also like to go around the table with the Planning Commission and please see how they're feeling.
Lance?
I think I'd like to hear the planning commission go first, actually.
Okay, straw poll. Go ahead.
I'm comfortable moving forward to the next step if we can do something that we don't usually do, which is ask for an extended comment period once the next draft is published. So that might put us out one more month. But I think giving the agencies and the people we've heard from more than that 21 days could be useful for us in the long run.
Yeah, it would be taking place in the Senate. All right, that's a thought. Yeah.
Yeah, I think we're going in the right direction. There was nothing really, compared to other processes we've gone through, there's nothing that's really been an argument, or it seems like we've gotten control of the big stuff.
Okay.
We're working on how to express ourselves better.
Okay.
So,
Gotcha. All right, who I got here? Well, Robin, you're up higher.
I agree with Joss that I think giving the length of the document and the detail and the number of other parties involved, that an extended comment period is probably helpful for everybody.
Allie? Thanks, Robin.
I have a question procedurally. We discussed a little bit earlier. I'll email my questions to Kay. She'll disseminate them to the board or at least the planning commission group so that we can all look at them. Is it possible for us to see another draft before it goes out, just to make sure we all feel good about it? Or is that atypical?
That would be atypical because we'd have to convene an actual meeting to take input from you guys. Definitely
So
when
that
we
would be a
have,
third workshop.
yeah, when we have, the new draft and are ready to publish it, of course, we send it to you guys as well. And you can individually, ask us questions, comments,
Given the trend of the feedback, Hallie, I'd say that, and what I'm hearing, I'd say that we're safe on moving to a consider. But if what you have in the way of comments or what we think of or what we hear from other people in the meantime compels us, we'll decide to set it aside for another internal work session if it comes to that. I
Yeah,
think
I guess just to answer the question then is, yeah, I'm fine moving forward then with the next step.
Okay. I certainly am. Back to you, Lance.
Thanks, Lee. Having heard that conversation, I would agree to move to a third draft and consider that go into the CPC, not for a work session, but for potential adoption, a recommendation to the commissioners with the caveat of an extended comment period. I'm curious, Joss, did you envision that being an extra week, an extra month? What were you expecting with that extension?
I don't know what might work best for Kay. I just think it is a complex document, and we heard several times that people were scrambling to give the level of attention to it that they wanted to.
Well, if we were to recommend a 30-day comment period, that would turn into 45 days in terms of the time it would take to.
plus we need time to work on the second draft. So, we probably wouldn't be able to have it ready for a May meeting. It'd be most likely be a June meeting.
Okay, I'm content with a 30-day comment period. That feels good enough. And I don't think that adding an extra 2 weeks or 2 months to that is going to net us any much more consideration. The other issue I think is for Tory, and that is we continue to hear concerns about preemption and duplication. And while we've discussed that, and we may have actually increased all of our understanding about those nuances on both those difficult concepts, I'd ask Tory to, in the general provisions, again, try to bolster that language and really attempt to clarify up front that we are not intending to make any preemptive actions and that we are not expecting anything in the way of additional work, but merely sharing work that already needs to be done. That to me is not duplication. That is hitting forward or adding another manila envelope with a document and sending it to us as well as to the state or federal agency. So Tory could help with that so that the next time around we are as clear as we possibly can be and can avoid having to go through that portion of the conversation again at length.
Yep. Yeah, yes, I'm happy to go through it again and continue to add because as you said, that's certainly been our intent in drafting. So I wrote down, I think when Mr. Larson was speaking about even looking at adding that from the first sentence, so the purpose onward. So yeah.
Thank you.
Okay, I think we have come to a consensus with the help of our friends in the back and the comments that we've received. And we will close this matter for the time. Thank you very much. Appreciate that.
Thank you for listening to us.
Of course. You've been over here. You know what it's like.
That makes it difficult sometimes.
Okay. Well,
Lee, I have a quick question for Kay. Last time you kind of walked out some dates for us. When do you want to get all written comments on this draft 3 by, or draft 2 by?
I'm going to talk to Tory and I'll let you know. I'll actually probably send out an email blast to all 175 people saying, last chance for comments on draft number 2. And then, you know.
And draft number
Just-
3 will be under consideration by
Yeah.
the planning commission.
So,
Cool.
Great.
Okay.
Yeah, if you don't get, also, if you don't, I think that we pointed that out to some of the agencies. If you don't get your comments in by X day, wait for the next draft too, so that you aren't repeating your efforts. So we were able to give like DRMS a heads up. Hey, you've got another draft coming.
Okay.
Yeah.
Okay, great. Thanks. Does this mean you're going to be leading us?
I'm gonna just sit quietly in the corner and tap out some
By all
emails
means.
with this wicked,
Wi-Fi.
Yeah, stick around for lunch, but we have to throw you out when we do the wetland special use permit.
Yeah, I'll get out of here. I just wanted to follow up and just get some information.
Sure.
Yeah.
Mhm.
Thank you, guys.
You bet. Thank you, sir.
We'll see you.
All right.
You wanna tell anybody listening, we'll be back after lunch?
I will, yes. Lance, you have your hand up. Can I help you?
Yes, Lee, I just wanted to thank everybody for your hard work on this. I really appreciate all of you, and that includes the public. And I wish you an enjoyable lunch. I'll be signing out. Thank you.
Okay, thanks. For those attending from the public, we are now going to we're going to recess for lunch, and we'll be back at 1 o'clock for the regular meeting of the County Planning Commission. Looks like we have one land use application regarding the Telluride Regional Airport. So get your lunch and we'll be back.
Lee, is that going to be on this same feed, or do we need to like exit and rejoin a different meeting?
Just stay on.
Same feed.
Yeah, we're going to cut the mics here. Just stay on.
Perfect.
We're
Thanks.
not, but it's the same feed.
Okay.
Yeah.
The ref.
Unmute guys.
Okay. All right, we have now reconvened the Planning Commission, San Diego County, for our regular meeting of Thursday, March 13th. We still have, make sure I'm not telling the story here, we still have all the same members of Planning Commission that we had. So a full quorum minus Matt. And our first item on the agenda is approval of minutes and Planning Commission and staff. Wow. First off, thanks for the little narrative. Little summary there, that's better than we had and helpful. I know it's challenging to characterize and summarize input, but we appreciate it. Any changes or comments?
Move that we approve the minutes as presented.
So moved.
I'll second that.
Seconded. Okay. How about that? Out of the park. All those in favor? And remote folks, raise your hands. Yes, yes. Okay.
Aye.
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 Who done this? Is that it? No, we're good.
That's it. Yep,
Okay,
we're 5 today.
we're 5 today. Okay. That's our moved and approved. Staff comments?
We do not have any land use applications that are complete at this time for an April meeting. So I believe we will be canceling our April meeting, which is in spring break anyhow.
Really?
So enjoy your time off.
Okay. You guys get that?
Off to Fiji.
Okay. Off to Placerville we go.
Yeah.
Come visit.
Uh-huh. It's a great place to unplug and unwind because there's no cell service. And let's see. We're going to have Ian's reappointment probably on next Wednesday.
Let this guy back in?
Yeah, I guess so.
You don't have to.
And reappointments, I think they can put on consent calendar. But we do still have that a vacancy. So if you know of anybody who is interested in serving and would like to fill Galina's position, they should apply through our online form. And we'll also be getting that ad published or adding that to our ad of vacancies. Other than
Hey, I think I filled Galina's position. So would it be for a new alternate?
well, so Hallie, you have moved up from senior alternate to regular voting member. And Robin, you've moved from junior alternate to alternate, but Galina's, the member who left. That's what I meant. So this would be a junior alternate position, yes.
Okay.
Who replaced Toby?
Galina.
Hallie. Okay.
Yeah.
She moved up to replace Toby. Okay.
It's my
Yeah.
only claim to fame. We got to get it right.
Yeah. And then Robin replaced MJ.
Oh, MJ.
Okay.
Need
Need a scorecard.
Yep. So yeah, no April meeting. We'll see you in May.
Okay.
I'll be out
Anything
of
else?
town.
Anything else of import? If not, then we'll proceed to the next item on the agenda. I believe Mr. Hubner is going to present to us today. Yes. Public hearing, land use application, proposal for a two-step wetland special use permit the applicant being the Telluride Regional Airport. Hereby represented. Okay. Take it away, John.
Thank you, Commissioners. The application is for a special wetland special use permit applied for by the Telluride Airport for their proposed South Side project. Just like to state, this application is for the wetland permit only. It's not regarding the development itself. We will discuss portions of the development that are proposed, but the actual application before us today is a wetland special use permit.
Don't we usually do them together?
In this case, the development activity requires a development permit, which is administrative review. And a lot of wetland special use permits are administrative, but this one is not because of where it's located. So there's differing levels of review on this one.
The development application will be administrative?
Yeah, the development permit will be administrative because it's already the activity has already been approved under the master plan, the airport master plan.
The applicant is the Telluride Regional Airport Authority. The Michael Perkins submitted the application on behalf of the airport. The location is at the airport itself on its main parcel and on a portion of lots 1 through 5 of the Red Tail Estates. The zone districts represented are public and open space. And the approximate size of the project is 35.1 acres. And the proposal is for new airfield pavements and hangars located south of the existing runway. The project activities include grading within 100 feet of the 2 mapped wetlands and of the compensatory wetland mitigation site, and wherein that is why they are required to submit for a wetland special use permit. The major development activity within any wetland or buffer zone in San Miguel County requires a wetland special use permit with a review under the 2-step special use permit process. The project itself is for a new connector taxiway and a large parking apron for private transient and based aircraft, and also includes new hangars. The project is multi-phased. Phase 1 will include grading and drainage improvements. This project will require a substantial amount of earthwork, and they anticipate there being a net excess of material, which basically means they'll be trucking it from the airport. Phase 2, they'll actually install the taxi lane and airport apron improvements, install utilities, proposed pavement of the perimeter road, and potentially constructing hangars at this time, although that may occur at a separate phase. The actual improvements were approved in the 2016 master plan and were illustrated in the airport layout plan, which we went through and approved for the new hangar building in 2024. The actual southern development pod was approved in the 2016 master plan. Although they had proposed changes, they ultimately withdrew those and kept it as previously approved. Wetland areas and buffer zones are located wholly on the main airport parcel, which is zoned public. So we thought it appropriate that this application come forward since it's on the primary airport parcel, which has been rezoned to public, which includes the uses, airfield improvements that are allowed. The applicant will also need to obtain a development permit and grading permits prior to commencing any construction. As Kay indicated, these are administrative approvals. The consideration of the underlying zonings for portion of the project area that are zoned open space will need to be taken care of prior to approving any development permit or grading permit. Or either a realignment of the proposed project must occur prior to the construction of the phase 2 improvements on these parcels. Wetland areas and buffer zones. As we handle these applications on a regular basis at an administrative level, mainly in the construction of residences. Wetlands, as defined by the Army Corps, are where water covers the soil or is present either at or near the surface of the soil all year or for varying periods of time during the year, including during the growing season. And it's interesting to note, we have included pictures in this slideshow, and wetlands aren't always just where water is. Often the water is either is dormant or off of the site for a portion of the year, but the soils and the plants that reside on those wetland areas are indicators also of wetland activity. A buffer zone is an area identified by San Miguel County where development could impact wetland areas and extends 100 feet around a wetland area. This is the case for this application where they are not proposing any activity within a wetland area, and the area of intersection is within the 100-foot buffer zone, and at that, it's just barely so. So as we will discuss later, there aren't any impacts expected to the wetland areas. The applicant performed an inventory of aquatic resources, commonly referred to as a wetland delineation, and included a field survey which was conducted on May 1st, 2024. 2 wetlands in the project area totaling 1.51 acres and 1.37 acre non-wetland water body were demarcated or mapped in the wetland delineation. The wetlands and the water body are located within the compensatory mitigation site. They are referred to in the application as stormwater detention basins, which we will identify in a photograph or an aerial survey later in the presentation. As stated, no impacts are anticipated within the mapped wetland boundaries or within the compensatory wetland mitigation site. Project grading limits do intersect with the 100-foot buffer zone around both on-site wetlands and around the compensatory wetland mitigation site. Adverse environmental impacts would be minimized through the use of best management practices by the contractor during construction, including the use of construction fencing to avoid wetland areas and buffer zones, and the use of erosion controlled logs and graded inlet protection. We have the site plan, which we'll show you very shortly, that shows the location of these BMPs. The revegetation plan is in accordance with San Miguel County Parks and Open Space revegetation guidelines and specifications, and the application also includes a weed control plan. Due to the size of the project being over 35 acres, we may include in any types of approvals and conditions of approvals that there be weed control and revegetation bonds to make sure that the areas are brought back as stated in their plan. The aerial map here shows the project grading limits, which are illustrated with the orange lines, and They are not anticipated to intersect with any wetlands, but would intersect the 100-foot wetland buffer zone. I hope you're able to see. It's a lot of detail. Wetland number 1, which is located within the orange project area and is illustrated as WL01 to the left of the drawing. And wetland number 2 is located approximately 1,100 feet west of wetland number 2. Wetland number 1 shares a discrete connection to wetland number 2 through a series of riprap drops, excuse me, and a culverted pipe that runs underneath the airfield tunnel road and connects to wetland 2. Several additional riprap drops are also located down gradient and to the east of wetland number 2. The project area, excuse me, I should also note, it's an interesting map. It shows Highway 145. The airport is located on top of the mesa, and the edges of the airport are sharp drop-offs to the Keystone Hill Valley. Excuse me. And also you can see County Road 63L, the Ilium Valley. Then our next aerial map has red outlining the nine adjacent sites that make up the compensatory wetland mitigation site. We also included the water body, which in some literature is referred to as a fire protection lake, but I'm not sure the exact use of that lake on the airport property. But the compensatory wetland mitigation site, comprised of the 9 sites as seen on the aerial map, was required as a special condition of the Army Corps permit in 2005. This mitigation was required for impacts up to 6 acres of wetlands in order to perform airfield improvements previously. And you might remember that was the lengthening of the airport runway and lengthening and taking out the dip and increasing the runway safety areas. The wetland mitigation site was determined to be successful by the Army Corps of Engineers in 2014, and no further monitoring was required as a condition of the permit. This is the site plan submitted by the applicant. It depicts the on-site wetlands, the 100-foot buffer zones, which I admit are really difficult to see here, and the project design features and the BMP types and locations. What I'd like to, just with the cursor, highlight this section. This is proposed to be covered with the protection, construction fencing and logs to prevent the flowing of water and sediment into the wetland areas. It's a large BMP, and you can also see many located squares here, and these are inlet grates, and those will also have erosion barriers surrounding them to keep any sediment from flowing into the wetland areas, nor into the compensatory mitigation site. These are blow-ups of photographs from the applicant's submission. And this is wetland number 2 viewed going south. So you can see that they not only looked for water on the site, but they also looked at the soils and at the vegetation. At the time, you'll notice some construction vehicles parked along the the, I believe it's the perimeter road or another road within the fence. It's a little hard to see here. But when they have been building the hangars, they had excess material in which they graded into the portion of the airport south of the runway. This is wetland number 1 with a view orientation to the north. You can see in the foreground the steep embankment, which surrounds each of the 9, as they're referred to as storm detention basins, or the wetland compensatory mitigation site. They're quite flat in nature and not necessarily looking like a area around a like a stream or a wetland area like that. I don't know if that was purposely done to avoid introducing wildlife or fowl to the airport, but at this point the wetland areas are not a large introducer of fowl to inside the airport boundaries, which would be a large negative for operating airplanes at the airport. This is a picture of the water body. As you can see, it's plastic lined, and the wetland mitigation specialists indicated that it is not connected by direct water link to any of the 2 identified wetland areas, nor is it considered part of the compensatory mitigation site. As part of review for this application, the following referral agencies were sent copies of the application, and we received comments from the highlighted county manager and the Meadows at Deep Creek Mesa HOA. Just really briefly summarize the comments. And the manager states concern regarding potential debris flow and rockfall hazard from the Telluride Airport south side during construction and from long-term operations. As many of you know, there was a slide at the airport a number of years back, which people have a long memory of, and just are concerned about any return to any fallout from this particular project, which has been engineered for a safe project. Nick Farku, president of the MDCM Homeowners Company, commented that development approval regarding the south side of the runway should have conditions that limit use of the dirt road that services the quarrying operation and the airport land outside of the secured airport area. It was a part of additionally 5 comments that are more have to deal with the development of the project as separated from this wetland special use permit. The comments will be used by staff during the review of the development permit for this project, and are appreciated that we have those in our toolbox now to take a look and help navigate our review of a development permit if and when one is received. Public notice was provided through the meeting agenda published in the Telluride Daily Planet and Norwood Post on March 7th, 2025. We received a number of comments from the public. The first being from Morgan Smith, a county resident who wrote in opposition to the proposed airport expansion plans, especially to the substantial increase in hangars and aircraft parking on the south side. Scott and Pam Bennett of Deep Creek Number 10 LLC, county residents, inquired if wetland permit applications had been required for several airport developments, and stated that all wetland areas and buffer zones should be protected, and certainly agree with that comment. The comments focused on the long-term use of the quarry road and on the parking, storage, and laydown uses on the flattened area south of the airport runway. These, the two wetland areas and a water body were identified, but the limits of disturbance for the proposed project are outside of the 7 other wetland areas in the previous compensatory wetland mitigation site. Any BMPs identified in the plan will be a requirement to protect not only the wetland areas, but the all 9 portions of the compensatory wetlands mitigation site. As in regards to whether a permit was required for the access road south of the tunnel, my understanding is that the wetland permit approved by the commissioners in 2005 covered that access road located south of the tunnel and north of the water body. And finally, there was a question whether a wetland permit was required for the new airport hangar, and I can state that no wetland permit was granted for the recent hangar development on the north side of the airport, but we will take a look at that see if one was required, and appreciate that comment. Charles Price also wrote, and he opposes any ancillary airport uses at the airport, which are located on what's called parking lot R. Currently, we have an application before us, a development permit application for the resiting of the lot where they take the cars involved in wrecks and things like that located on the airport. It was previously sited on the north side of the airport, but with the new hangar project has been sited to the south side. And we also have a parking area that is leased by the town of Mountain Village for overflow resident parking, and includes vehicles and camp trailers for those residents who are impacted by the development for the, and I'm blanking on the name of the
VCA.
The VCA apartments, the remodel and rebuilding of those, and then also for the new Four Seasons Hotel construction project. And so what we have to decide, as staff is, first of all, is that use of that airport road, is that an adequate use or an okay use of that road? And, what is the public benefit of those parking spaces? And the Planning Commission, or I'm sorry, the BOCC had previously approved the parking lot for the, the wrecks and things like that in its location on the north side. We're just looking at it for its new location on the south side.
John, can you just orient us to all these things? I'm looking at the map. I've kind of zoomed in on the map that shows all the construction details in the actual packet, but from the wetlands and the new hangars, where's the quarry road? Where's the parking? Like, just so we all know what you're talking about.
You bet. If you can see my cursor, the quarry road continues here. You can see where it's proposed to be resurfaced.
So south and then to the west of the wetlands areas.
And then outside, and majority of this from this portion is outside of the fence of the wildlife fencing surrounding the airport. And I just lost my cursor. Oh, there we go. And below then we'll cross over to here and is access from Last Dollar Road. Does that help orientate?
Yeah, so then when, was it Price or someone was talking about airport security and all these parked cars, and you're talking about overflow parking, is that all off there to the east?
It's yes, all of it's to this portion. And I'll let Kenny address any issues with security at the airport. It isn't a well-traveled path, and it also is patrolled by the Mountain Village Police Department, at least on a daily or somewhat daily run.
Thank you.
You're welcome. And really getting close to the end here. The project avoids mapped wetland boundaries and minimally intersects the 100-foot buffer zone around both on-site wetlands. The San Miguel County's wetland regulations basically have two standards that we look at. The first is to avoid the wetland area, and this project avoids the wetland areas and only intersects with the buffer zone of the project. And then secondly, if there is an intersection, that any environmental effects would be minimized due to the installation of construction fencing to avoid wetland areas and buffer zones. And this is to, mainly keep out heavy duty construction equipment, especially during the grading project. I hope I say that this is going to be there's going to be a significant amount of grading done with this project. And also including the installation of an erosion control logs, which will help to reduce soil erosion and retain sediment by being used along contours or at the base of slopes and at graded inlets. Additional BMPs, if these are not sufficient, will be included in the phased project as necessary. In addition, the contractor will have to submit a stormwater pollution prevention plan in accordance with FAA and state standards. The wetland specialist who provided prepared the application on behalf of the airport states, the project as proposed is not likely to negatively affect the function and conditions of the existing wetlands. They go on to state that it may lead to additional water diversion because of the new pavements proposed into the wetlands as a result of the impermeable surfaces and associated runoff. The additional hydrology, which is one of 3 items that you look for in a wetland, and provided by the project may lead to an expansion of and quality of the wetlands and increase their function to slow discharge from the airport and to accumulate sediment and other materials originating from typical airport activities. So basically, most of the project is outside or is completely outside of any wetlands. It narrowly intersects the 100-foot buffer, and there is a potential, but it's not really a consideration for approval, but that additional runoff could conceivably help increase the quality of the wetlands by providing more water to that area. And provided a sample motion that includes conditions regarding that the BMPs and written representations of the application be met. It's extremely important regarding the construction fencing and erosion control logs around the graded inlet protections to minimize impact to the adjacent and downstream wetlands and water resources. And prior to beginning grading, to provide photos of the BMPs to the planning department upon installation. All disturbed soils will be revegetated, which will help protect the wetland areas from surface runoff and runoff associated with the project, and also the control for invasive plant species as well. And finally, our final condition is that we will schedule a final inspection to certify that compliance has been made with the conditions of this wetland permit. And we'd be happy to answer any questions or concerns the Planning Commission might have.
Okay, thank you, John. Was there any thought to a site visit on this? Seems like there's some visuals.
Yeah.
Pictures are good, but
I believe staff conducted a site visit. We
June
did-
11th,
Yeah,
2024.
yeah, we didn't schedule one for you guys largely due to logistics.
Yeah, weather and all that. Uh-huh. I see. Okay, thank you. So, excuse me, for our normal process. Staff, commissioners, questions for staff in regards to the application?
I first just have a clarification question. So in January 2024, we looked at a master plan update. Is that what it was? And at that time, they wanted approval for increased uses on the north side. So what you're saying is that by them not asking for approval for anything on the south side, even though there was an update to the master plan, it only affects the north side and they get to continue to do what had previously been planned on the south side? I'm trying to understand.
Sure. There's been a number of different updates at different times, usually corresponding with a change in the airport's, plans, future plans. Some of them are, 0 to 10 years out, some 15 to 20, and others 30 years out. The 2016 update was mainly focused around the, changes to the runway and things like that, but also included the south side improvements, which at that point were not really addressed, during that update, but were clearly, presented, as part of included within the airport master plan and also on the layout diagram that was part of the airport master plan. So they've always been upfront about what they proposed on that south side. It's granted, it's more of a conceptual look at, it doesn't necessarily get down to how those improvements are going to look on the ground, but that are very key on the location and extent of those improvements proposed. So I guess what I meant by that statement was that the previous approval from 2016, there weren't any changes made or any changes approved into 2024 to those south side improvements, although they did propose some during that time. But after hearing from the public, they withdrew those types of improvements that they had been proposing in 2024 and just went back to their plan, which had been approved in 2016.
Okay, I mean, I guess that is what it is, but I don't think I totally understood that by them saying they were no longer asking for approval for what they had updated their ideas on the south side. It meant that they were still gonna go ahead with development on the south side. I'm not sure. That was a year ago. I may not be remembering all the details, but I'm not sure that was really clear.
In the 2016 effort, which is not that big, we included in the master plans envisioning the potential for the south side, if you want to consider it the baseline of the south side expansion. And the 2024 application was a request to expand and enhance and improve upon that development, and we declined the opportunity to add that to the master plan. So the 2016 master plan still stands.
Right.
It's basically where that comes out.
All right.
For better or for worse.
Can you specify how far into the wetland area buffer zones this impact will extend?
I didn't have construction drawings. If I had to make an estimate, I would say that it is no further than 75 feet from the wetland.
75 into 100 or 25 feet into the
Into
buffer
the
zone.
100, right.
And that buffer zone, I mean, I assume it's not arbitrary, it's designed because that's the amount of space that is thought to be protective.
Yeah, it's a county standard that we as San Miguel County and other jurisdictions don't necessarily take a look at the buffer zone. They only look at the wetland themselves. San Miguel County has a policy of maximizing protection of wetland areas by not only triggering permits when they're within the wetland, developments within the wetland, but development within the buffer zone.
And
That's the reason for having this process, is to demonstrate that whether or not it's okay to go into that 100-foot buffer zone.
do we know anything specifically about the slope stability south of the wetlands? Going down towards the highway? When you talk about the engineering for the project, does that mean something recently has been evaluated in terms of that slope stability?
I don't have any construction drawings. We have a basic conceptual drawing of where that, where the boundary of the surface disturbance limits are going to be on the project. But as far as having an engineer look at that, we haven't received those types of drawings or any drawings to that scope. I don't know if Kenny could speak to whether those are available yet. I don't know.
Okay. And then finally, I see that there's reference in the application to the reason that this should be appropriately granted is because it's part of essential service facility. And it referred to a definition in the land use code that I looked up. And from what I can tell, that really is about kind of gas lines and water lines. And I didn't see anything in that definition that really encompassed.
We actually didn't look at that or consider that portion of the application. Since that has to do with floodplain development, we're actually in the portion of the code dealing with wetland permits. And the reason we would be able to, or the reason you would be able to approve the application is based on its merits would be because it's only within the buffer zone. And they had listed that and one other reason or three reasons why it could be, but we didn't consider that because it's not relevant.
Okay. Okay, I think that's what I've got for now. Thank you.
Thank you.
Ally?
Yes, thank you. I have a few quick, just clarifying questions. I think you've already hit on some of these, but when we talk about the airport master plan, is that something the airport developed or that the county has developed and adopted for the airport area?
Good question. The airport, especially on the public zone parcel, they are a quasi governmental entity, and as such develop their own master plans. And we as a guarantor, the guarantor of the airport, part of we're involved in their granting processes and in the formation of the airport. That is why we are the body that actually gets reviewed in front of, and it's a requirement of the public zone district that a master plan be presented and approved by the San Miguel County.
Yeah, and in this case.
So the county has adopted this.
Yes, and in the case of the airport master plan, that is one that's actually, the planning commission provides review, and then the BOCC actually adopts, as opposed to our other master plans.
Okay, great. Thank you. And then where is Red Tail Estates? It's mentioned in the titles, but what is that? There aren't houses there.
No. You can actually,
Let me show you
That
on
one.
this slide right here. If you can see the cursor.
Yep.
This section of the airport is referred to as I'm referring to it as the main airport parcel. It's approximately 300 and some acres and is zoned public and contains most of the contains all of the activity other than a portion of it on lot 1 of Red Tail Estates to the north. These lots that you see south of the airport that actually go down the steep embankment and cross Highway 145, they're known as lots 1, or this is lot 5, lot 4, lot 3, lot 2, and lot 1 of Red Tail Estates. The proposed project is proposing to enlarge, not enlarge, but is proposing development or of the project on those lots. They are not zoned public, they're zoned open space. And that is although airport type improvements are allowed or at least contemplated in that zone district, in keeping with the airport, not to allow development that would be hazardous to the airport in there. But as I was saying, that they are not, it is not zone public at this point. And so prior to any phase 2 improvements, being cited on there, they would have to either change the scope of the project or change the zoning on the open space parcels.
Does the airport own those lots?
Yes. They've owned them since 2003, and it was part of a purchase by the airport with FAA funds to help create a safety buffer and also to keep uses away from the airport that would be hazardous to air flight.
yeah. And so this is something that we're going to continue discussing with the airport and, determine how to move forward. And it is conceivable that you may in the future see a request for rezoning a small part of Red Tail Estates concurrent with a property line adjustment, and property line adjustments go to the Board of County Commissioners. You guys don't review them. So there may be something in the future we just don't know right now.
How did these parcel designations come about?
How were they zoned?
No, like
Pretty strange shapes.
just how was that developed if there's no,
We don't know. I mean, we'd have to go back and, delve into the file, and we have not, had a full chance to do that. But yeah, why the decision was made to create all those very interesting parcels,
Okay.
I couldn't tell you right now.
And that actually runs on the south side of the highway, but north of Two Rivers.
Yes.
Yeah, it comes all the way down to it actually abuts the open space parcels.
And they're open, the entire parcels are open space.
Well, there's open space and conservation parcels that are along Two Rivers in the Ilium area.
Mhm.
And so, yeah, these parcels cross the highway and go over there.
One thing that is
So
interesting.
oh, go ahead.
One thing that is interesting is lot 1, which is located to the north of the airport, and it actually encircles the airport and it then comes back down on this lower portion. This portion that you see in the north section of the lot is zoned public. So and like Kay said, we haven't delved into this yet. It does have split zoning. Half of the lot is zoned public and a portion of the lot is zoned open space.
Okay.
That's
So I guess
interesting.
then as a follow-up to that real quick, what's to the west then? And did the airport contemplate developing these hangars to the west of this whole wetland area in what is already public? And then, I don't know what that next lot over is, to the west of parcel 1 or parcel 4?
Well, you basically have residential property.
Well, no,
To the
it's farther
southwest.
west on the airport property. So to the southwest, there's actually a quarry. There's an active quarry.
Oh, I'm sorry, to the west.
Yeah.
I thought you were talking to the east.
Yeah.
So there is, Kay was saying there is an additional lot 6
Yeah.
that went through a rezoning process approximately at least a decade ago.
Yeah.
It's where the quarry operation is.
But, yeah, in terms of putting hangars and, you know, taxiways and everything, I believe there's a bit of a terrain issue.
Okay.
Kenny's nodding his head.
Yes.
And
Okay, so they can't simply move it.
yeah, and it also appears from not this map, but one of the other maps that in order for these east and west hangars and aircraft parking apron to avoid the wetlands, it gets pushed over that property line into those lots 2, 3, 4, 5. If you go to the prior, I think it's the prior slide. And that's, so you, that one. So you can see the red line here, which was going around the buildings and the apron, and that red line goes through the north end of lots. It looks like a little bit of 1, 2, a lot of 3 and 4, and just a tiny bit of 5. And so I think, Kay, you mentioned just in a few minutes ago that aside from this wetlands discussion, there might be a discussion about something to do with property lines, because in order for them, in order for those buildings on the other slide to avoid the wetlands, they've got to get pushed sort of to the edge of the precipice, which is actually on into those open space slots.
Yeah, and that's something that needs to be addressed relative to the development permits. So, you know, this is the wetland special use permit is one step in the whole process. And obviously this all, if you guys should recommend to the board to approve this today, that does not automatically approve all the development, because we do still have all these other issues we have to resolve before we can issue that permit.
Is this the right order though? Talking about wetlands before we even talk about zoning?
It can go either way.
Okay.
Yeah, we had the application and it was complete, so.
So the essential question that we're being asked is about the approximately 25-foot incursion into the buffer zone.
Correct.
That's all we have.
That's really what we're talking about today.
And the reason for that is not because there's necessarily going to be construction as being the intrusion, but the work is going to be the intrusion.
Correct.
Yeah,
also
so
in the contours of the ground within that buffer zone permanently.
I don't believe they are. I think it's just the extent of the development. It's not necessarily property that's going to be developed. It's just right on their edge of development.
But they're gonna be doing like building up slopes, or, I mean, what was clear in the packet is that they're going to be paving more surfaces up above the wetlands area. But within the buffer zone, can you be more specific? Maybe this is a question for Kenny about what will actually change the contours on the ground.
Sounds like an applicant question. We'll get to that.
Okay.
We'll be asking Kenny that, I think. Okay. Other questions for John? Okay. Okay. Let's give Kenny a mic. Oh, he's got one. Will you be speaking today, sir?
Yes,
On
sir.
behalf of the applicant, being the applicant?
Yes, I think I can address a lot of the questions that
Please do.
were today. So I guess I can work backwards and address your very good question. It's our understanding because during construction, there is disturbance within the buffer, but there absolutely is no intention of changing the contours or anything else when the construction is complete. It'll be reseeded. And that's kind of what activated us to do this this request, because it was just a slight disturbance during construction. So that's the expectation. I think, does that answer your question? Okay. Let's see. Now I was trying to keep this track in my mind. The first question was regarding the remote parking lot. That's over on the south side, and there's a flat area off the quarry road before you enter into the fence. The intent has always been, and this is the one that's leased to Mountain Village for their remote parking for employees, as well as because of the two big hotel projects and what have you in Mountain Village. They need an area for employees that are working either on the projects or working at the ski area. Like right now, it's utilized primarily for a lot of the people that are working for Teleski, and they're continuing, they park their cars there and then it's coordinated transportation, but it's not heavily used in terms of the number of activities. And yes, indeed, Mountain Village Police does maintain it because we certainly didn't need that headache. And so, but the intent of this whole, the reason and the justification is temporary. This is a temporary use. There's no long-term vision. It's not in the master plan to even improve the roadway to the quarry roadway. There's no intention of utilizing that as a long-term parking solution or what have you. We're just trying to be good neighbors to the community and have it as a use really for a temporary use until the improvement projects are in place, as well as Mountain Village has committed to adding additional layers or decks to their current parking in the town center there. And so this is really a bridge to those issues. I believe that the reason why I think some of the comments were there related to, and concerns, and justifiably so, was if you recall, there was the two affordable housing projects that happened in Mountain Village last year in 24. And the airport and a lot of that property on the south side was utilized as temporary staging. It was temporary staging until they were ready for those pods, the construction pods, to build those apartments and housing units. And I think the county and as well as everybody was a little bit annoyed by the amount of traffic that generated those big units going over to the south side. Thankfully, that's all finished and completed. And so now it's just utilizing as a parking area, primarily for Mountain Village. So that's a temporary use. What was the other? There was another question. I think you asked a really good question related to the zoning. We've committed to, this is more of a horizontal overall grading for the build out on the south side for the eventual use of hangars. The project that's planned for this year, this is federally funded, and what spawned this special use permit request was really for a taxiway as well as a parking apron for aircraft. And really probably about maybe a half of that area will be paved in this first phase. And then I think, as Kay mentioned, then you have the phase 2, where we definitely need to sort out some of these issues and the zoning questions and what have you. So we'll do that. What else? There was another, am I missing?
Have any engineering reports about slope stability?
Yeah, so we have all the engineering from the original. Oh yeah, that's a really good question too, because one thing I wanted to address is that this whole development area is to the west of where let's call it the big slide. that occurred that created a lot of feats of engineering, if you will, to restore that hillside, as well as detection, slide detection, what have you. Our engineer currently has all of that data engineering, construction reports, as well as soils, geotechnical engineering, all that is on record and was included, but we are staying, this whole project stays definitely to the west of that whole, let's call it delicate area, that there was a lot of resources that got a lot of people, was a big problem, it was a big issue. So we're staying well west of that whole area. And if you look at that roadway, the straight line or the entry road, quarry road, if you will, inside the fence, that straight area, east-west, kind of toward the end of the runway, that basically is the edge of not only the safety area of the runway, but that's where you have the wildlife fence, and then you have the drop of that slope.
Okay.
A number of the public comments we received, although not completely directly on point with just the wetlands aspect of it, were in regards to the various temporary uses that are going on the south side.
Yes.
Are all of those slated to be terminated on when you start development of what's in the master plan for the south side?
The answer is yes. I mean, there's 20, the Greenwood Mountain Village, which is kind of the most current one, is, that expires in about 20 months. So that hopefully will go away. There will be, as John mentioned, there will be a small portion that will be utilized for the, for CDOT, for the storage of, for the towing company, that has to take the vehicles, the wrecked vehicles, and stage them there. That used to be on the north side, but will probably be on a small piece of that. But other than that, everything, even the mine, even the quarry is, we're doing a short-term, which has been all improved under a development permit, but the other temporary uses, absolutely should, by the time we go, let's say we start going vertical with hangars in about 3 years, the Mountain Village uses and the other temporary uses that we've been using should no longer be necessary, other than for construction. But even with construction, again, that's a temporary use, but then they go away in about 150 days or what have you.
And then what will be the designation and use of that outside the perimeter road?
It would just stay the way it is. I mean, I don't think, I mean, what we're learning, the way these things have been going, I don't think I would have to be an absolute fool to try to propose any other developments on that flat piece of land over there. It's really a nice place to stage construction equipment temporarily for projects, and that's about it.
Okay, so that road was originally envisioned to be temporary itself, wasn't it?
Yeah, I think it was, but I think it was, I think the support and it was more for the quarry, which has been there now for over 20 years. So, and it is running out. I will say they're running out. We're probably going to do a 5-year extension, and that was all approved properly and through the county, of course, and what have you. So, but even then, that's going to probably end. But I think the roadway is always going to be necessary as just more of a haul or construction access roadway for improvements over the rest of the life of the airport. And emergency access and what have you sometimes too as well.
Do any of the current uses impinge on or encroach on any of the buffer zones for the wetlands?
No.
I'm looking at an aerial image and I'm still curious about the space between these wetlands and then to the west, there's another little water retention pond and then the quarry. What's the use of that land? You can see a big chunk of it here on the screen. From the edge. I mean, it seems like there's advantages to using that land instead of using this boundary zone with questionable technical subgrade. So what is that use?
Holly, you might want to try turning off video. Your audio was getting a little choppy there.
Okay, sorry.
Sorry?
Yeah, I'm just looking, basically due left of this red
Yes.
panhandle
So,
thing.
okay, so the big issue there is the ground rises significantly, about 25, 30 feet up that area. And so that's why from an aviation use or other uses, it's just not feasible. Yeah, you're right. Once you get up there, it's nice and flat and what have you, but it would never be really feasible to access the airfield for aviation. You got to have pretty flat areas.
Okay. Yeah, I mean,
So you see
I mean,
where the roadway on the cursor, can you show the roadway under the runway, the tunnel? So yeah, so it kind of goes, yep, there you go. That's about the limit for any construction because right there within that, those are the last two ponds, if you will, of the mitigated wetland area. And that can never be built beyond that to the west of that. It's just the terrain as well as the ponds, they get kind of big and wide there, north and south. So it's just, in the master plan, it actually did show buildings there. But it's just not feasible to put buildings there because of those ponds.
right. Even if you had a runway that wrapped back around the red zone and accessed your runway off to the right there, then.
Right, like a taxiway, yeah.
Yeah.
Yeah, it's just the standards for building any kind of parallel taxiway on that site, it can never happen.
Okay.
Okay. Other commissioner questions?
I have comments, Lee. I don't really have questions.
Well, feel free.
I don't know if there's any other public comment.
Okay.
There's at least 3 members of the public.
Yes, we do have public members that don't have any hands raised, but I haven't opened the public thing yet. How I hang on to those until after the public. Any other commissioner questions? Okay, then we will open the public comment session. Reminders of the usual rules, some of which you folks know them well. 3 minutes plus, and identify yourself and direct questions at the commission. Go ahead, Nick.
Can you hear me?
Yes, sir, we have you.
Perfect. Hello, everyone. Nick Farco, representing the MDCM Homeowners Company, which is the Meadows at Deep Creek Mesa. And Dirk DePopter is here too. He will likely have some comments after mine, but we're both board members here at MDCM. First off, thanks to Kenny for clarifying some of the intent. That definitely makes us feel a little bit better over here at MDCM. But moving into the detail, one of the things I wanted to clarify was something John had said about that we were requesting conditions just about the dirt road. And I think it's important to differentiate between the dirt road and the uses that the dirt road services. And I think, you know, without uses, there's no need for a road. So I think, you know, focus to be on that parking lot and other uses is probably worth mentioning. And if I could, I was going to ask Lee, would it be possible to put our Exhibit B on the screen? And it was only to orient the planning commissioners, since there was a question earlier about where is the road at. You know, our exhibit is just simple, kind of cartoon-like. If that's possible, that might help everybody see what I'm talking about and what we have been talking about without any ambiguity.
Do you have a copy of that, John?
It's in the packet.
Mm-hmm. Yeah, we can do that.
That would be terrific. I'm watching my 3 minutes go in the can.
Oh, we'll start you.
Okay.
Unless you want to go ahead and raise any other issues.
Yeah, you know, I can start talking, and as long as it gets up there at some point, it'll help reinforce. So I think the major point that we have that actually was learned in the first couple of minutes here was that since the development permit is administrative only, our comments become more relevant at this point in time. I think coming into this, we were very acknowledging that this is a wetland special use permit. So why the heck are we talking about things that really aren't wetlands related? But since the development permit's administrative only, we don't want to be in a position where we just got to trust that the conditions get applied that we're asking down the road, especially since it's not going to have the public process like we have here. So we're really requesting that the Planning Commission memorialize the conditions now, so there's no ambiguity or need for trust in the future. And really our intent here is to preserve the historical plans and agreements, of which again, Kenny acknowledged, so thank you for that. The airport's aware of this. And so on the screen, really the issues, there it is. Actually go one more to Exhibit B, if you could, John. It's just a simpler.
No, forward to Exhibit B.
There you go. It's just a simpler schematic here, is that the temporary pad, and I think it was, I'm not sure who it was, one of the commissioners, I think it was Hallie, asked about where that is. That's the blue arrow. And then the road that connects to it is also in a darker blue. So really it's the pad out there and then the road that services the pad. But beyond just talking about that, the leases are a big deal. And to limit those leases, I think we all look at, well, Town of Mountain Village is leasing this and their uses. Are they truly benefit to the community? Are they truly in harmony with the local community as the master plan calls for? And I would argue pretty solidly, no. I mean, we're going to allow use for the Four Seasons Hotel, as something that benefits a community when it impacts the existing community greatly. And even if it's temporary, as Kenny had said, that is still pretty impacting when that dirt road has trucks cruising every second down it, kicking up dust and loud and noisy, not to mention use on Airport Road. So I urge you guys to look at that bigger picture, look specifically at the 5 conditions that we requested be applied at this juncture, and do something at this juncture so we don't have this ambiguity in the future. So I think that's the only one other question I had, and if it can be answered today, great, is where does it specify in the land use code? I couldn't find it that a development as significant as this proposed development in the airport is an administrative review. And again, I'm probably missing something because I certainly don't have the land use code memorized. Thank you, guys.
All right, so thank you. We don't have anyone here, so Dirk.
Can you hear me?
Yes, sir.
Oh, perfect. Thank you. Nick already asked a series of the questions I was going to ask. I am a little bit surprised that we have kind of the cart before the horse here as far as getting a wetland special use permit, and then the development permit is actually an administrative permit. I'm surprised of that structure. As most of you probably know, I've been intricately involved in the development of many of these things on Deep Creek Mesa. Quick side note, those funny lines for property lines that you saw with all those red tail ones, those were created prior to the ownership of the airport park by the airport authority when it was still owned by the El Soro development company, and that was more or less done to preserve their development rights. Just a quick side note. So that's where those things came from. Couple of observations. I was not aware, and I've been intricately involved in the quarry situation, and I was not aware there was going to be an extension requested. Kenny mentioned that. I had spoken with John Gallegos, who's the operator, a few months ago, and he said that he was going to be finishing up. And John Hubner and I usually go look at the revegetation and the recontouring and everything else, and that was hoped to be done again this spring. But I'd like some clarity from Kenny at some point if they're thinking about more quarrying, because I thought they ran out of quarry stone. So then also, temporary staging was never approved in this area that is pointed out to the temporary pad outside the fence. There has never been an official approval or any mechanism for this. And it's, you know, like, yes, I can understand and be sympathetic with the temporary nature of this. But, you know, I became acutely aware of that when all of a sudden I couldn't get out of my own road, you know, like to onto the airport road, because the thing was blocked off at a whole series of these big ass boxes that the town of Montevillage, you know, ended up using over there. You know, I'm sympathetic to trying to get, you know, this temporary use, you know, to expire. However, any future uses, including, you know, the storing of car wrecks, which nobody can tell me that storing of car wrecks is beneficial to the safety of the airport operations. You know, so any uses south of the runway, you know, like other than access via that road for temporary emergency uses and potential construction uses, should cease to take place very shortly. I mean, this has been going on too long, and obviously people forget about why this all was created in the first place. So those are my comments. I just would like an answer, you know, like on the question of like, why is the process reversed? You know, like, it doesn't make any sense to me.
All right, sir. Thank you. Mr. Bennett.
Unmute. Hello.
Hey.
Thanks for giving us time to speak a little bit. I agree with some of the other comments from Dick and Nick, so I'm not going to review those again. Adding to it, Lee, you mentioned would it be appropriate for a site tour? And I think it would be a really good thing for a site tour, especially having two new members on the board. And the site tour was quite some time back, so I think it would be beneficial for the whole board. Further on Dick's comments about retail estates, yes, the Eldesor family did plat those as 35-acre lots to preserve that 1/35 subdivision where we didn't have to go through a process at a time when the state was considering changing that rule to a 1/140 or 1/240. Later, then the airport purchased that property, started a condemnation, and then worked out a deal with the family to purchase that. At that time, all of Red Tail Estates was zoned forest ag. And then the airport rezoned a section of those lots to open space. So that's the quick and dirty history on that. Thanks for your time, and look forward to hearing more deliberation.
All right, thank you, sir. Any other members of the public would like to speak up? For their mouses? Guess not. All right, thanks very much. That concludes the public comment portion of today's consideration. And we'll turn back to the Planning Commission and staff. Yes, ma'am.
So I just wanted to respond, the question was about how, why are these, developments only approved by a development permit, not an SUP? And it goes back to the fact that the airport is its own governmental authority. So what happens with that is there's the master plan that is approved by us, and then all development under that master plan goes through our administrative permitting, but it's all the concept of the uses. The uses are already in place. So you guys don't see all that because that came in at the master plan. So it's us wrapping up the details so that it can be properly permitted under our county regulations.
Does the master plan, I haven't looked at that monster document in several years, but does the master plan envision temporary uses like record
That-
yards?
And
stuff
that
like
is one thing that's a little bit outside the master plan. It wasn't included in that. And we're having conversations internally, you know, among staff and with the airport on how to deal with those temporary uses.
Okay. And so in some respects, that settles the question of whether we've got the cart in front of the horse, because if it's under administrative review, there isn't necessarily a public process. So it was felt best to get the public process on the tables and taken care of.
Right.
As the case may be. Okay. Yeah, go ahead.
Do you have the discretion to make that next phase have a public process, given that there's concern about these extraneous uses?
I would definitely have to look into that, you know, under statute, the airport as its own governmental entity, you know, experience or enjoys some autonomy.
Right.
So I do not know.
And is there a difference when we're looking at the map between what happens like within that fenced area and without? In terms of whether they would need special use permits and what's covered by the master plan?
I'd have to look exactly in, I don't have an answer for that right now. I'd have to go back and look at the whole plan and see exactly what's approved and what's not. And whether it's inside the fence, outside the fence, I don't know.
And the fence is not the property line.
Correct.
Yeah.
Well, given that it's not appropriate for us to make much of what the neighbors have expressed concern about part of this wetlands review permit, as far as I can tell, I at least would speak up for the possibility of a public process ahead of the development, even if we can't say yes or no to the actual development. I don't know. It definitely feels a little frustrating that there's not a way for some of that stuff to be hashed out.
Hallie?
All right, trying to find the right button to push at the right time here. I'm gonna leave my video off just because my feed might be kind of wonky here, but I wanted to spin us back specifically to the wetland conversation. There was a question about how far into the buffer zone we're encroaching. And if you look at the meeting packet on page 119 of the PDF, there's a figure that shows the construction grading, delineations, the 100-foot wetland buffers. And for that wetland 2, it shows that the edge of grading would be a mere 21 feet from the edge of the wetland. So extending, what is that, 79 feet into the buffer zone. And then for wetland 1 off to the west there would be a 64-foot buffer to the edge of a road. So again, extending, my math is hard here, 35 feet, 36 feet into that buffer zone that we've established. I also took the opportunity to do a little digging online. EPA has some documentation about why wetland buffers are important. And one big reason is that the buffers help reduce sedimentation and pollution from getting into the wetland itself. So the wetland's great for filtering sediments and for creating wildlife habitats and such, but the buffer zone actually protects the wetland. And in this particular document I found, it's talking, and this is from the EPA, it's talking about how a buffer zone of anything less than 25 feet is basically negligible. It doesn't do its job to protect the wetland. Anything less than 50 feet is questionable. And really that 100-foot is the key here. So from my perspective, especially with wetland number 2, having a road that's going to be used by aircraft, and we know there's jet fuel involved and that sort of thing, with a mere 21-foot buffer around that wetland, that doesn't seem to align really at all with the intent of our land use code surrounding wetlands. And so I guess from my perspective, I would not want to approve that as is without additional wetland mitigations. I could start spitballing mitigation opportunities, but then that would further be expounded by the fact that all this pavement would create potentially larger wetlands, which would then further extend the 100-foot buffer. So that's my 2 cents on the wetland issue. And I would say if we're gonna pursue approving this, I would also want to have additional wetland mitigations, either an additional cell off to the west or something along those lines. That's where I'm landing right now.
And you're pulling that information from the map?
Yep, so the figure I'm looking at is in our agenda packet. It's page 119 of the PDF. Let me zoom out here. I've zoomed way in on it. Let's see what it's called. It's a construction drawing by Dibble. It's called Telluride Regional Airport Southside Development, San Miguel County.
Yep.
SUP exhibit. And you can zoom in on wetland 2 there. I don't know if you're showing a screen or not, but you can zoom in on wetland 2 and you can see the 100-foot buffer, and then you can see a construction call out showing the edge of the blue wetland to the edge of what appears to be either riprap or road, and it's 21.62 feet. And so that, we're not talking about a minimal encroachment here, we're talking about an 80% encroachment. And so, again, I don't know that it's really in our interest to start creating precedents where we just say, sure, encroach on a wetland without having some kind of mitigation.
I mean, there is proposed mitigation, right? They're gonna fence off the wetland area, and the work they're doing is just temporary, and then it will be left as it is now. Is that correct?
That is correct.
That's only during construction. I mean, buffer zones exist to protect wetlands for perpetuity. And so after construction, you'll still have this road 21 feet from the edge of your wetland, basically right at the top of your berm, being used by aircraft that also have jet fuel and whatever else runs off of the paved surface there. So again, I'm not saying don't approve this drawing as is, but I am saying we should see some mitigation, like add an additional wetland cell or something to help offset these impacts.
Sorry, Hallie, I'm trying to understand, because what I understood them to be saying is that the encroachment into the buffer zone is basically the moving of equipment through, I don't know how much of the buffer zone, we've got maybe 25 feet. And that after they're done constructing, there won't actually be anything constructed, like paved surface, road, anything that is within the buffer zone. But what you seem to be saying is that that's not what the map is showing us.
That's definitely not what the drawing shows. It shows the wetland buffer fully extending into the paved area.
I don't think the paved areas.
Yeah, it's tough for us to see on the page. Any clarity you can offer there, Kenny?
I don't know what that rocky little strip represents, because it's not in the legend,
Yeah,
but the paved area is the gray, from what I understand.
Can you pull up the drawing, John? And
I'm trying to get to.
share
I can
screen?
share, can I share my screen? I don't know if I can share my screen.
Yes, you can.
Happy to. Let's see if I can figure out. Oh, share screen. Look at that. There. Let me know when you guys see this.
Yep.
Okay, so here's your wetland. Here's the 100-foot wetland boundary. It's this black hashed line. It goes right there, and continues around your wetland to right there. Here is the dimensions showing from the edge of your wetland to the edge of this riprap. The brown, I can zoom in even further. The brown is showing your, gotta go back to pan. The brown is showing your sediment log, sedimentation log. So right there, that's where your sediment controls are going to be. But this riprap and whatever grading happens here is still all within your 100-foot boundary. Here's your 100-foot boundary right here, this gray line.
Is that riprap existing? Kenny, do you know?
Yes, I believe that is, yeah,
Yeah.
yeah.
Yeah, so, these cells have already been created. So, yeah,
Yeah, that's rock and riprap there.
Yeah.
It's already there.
Is
Yeah.
that taxi
But look
lane
here.
area new? That's going to be new paved area?
That would be the new area.
So that does have permanent paving within the buffer zone.
Yes.
That must be the minimal encroachment you were talking about, John.
Just trying to understand this drawing.
Um,
I mean, what I see right here is very clearly pavement inside your 100-foot buffer zone. And the edge of pavement is not going to be the edge of grading. I mean, your edge of grading is certainly going to go further than that.
Hallie, what page of the report are you on?
This is page, let me see if I can move this out of the way.
After
119.
After the exhibit B. That Nick submitted, it's the page after that.
And again, I'm not saying I wouldn't vote to approve this as is. I would just request an additional wetland cell off the west end, which has already been established as an area that can't be used for anything else. So if we're going to impact, and really it would be all of these cells, even though this one's the only one that has a delineated wetland in it. It makes perfect sense to me to say, hey, we just want to see you mitigate this by adding another cell right here. Create some more wetland for us. Protect these wetlands. Here's the other one I mentioned. Let me pan down to it. So again, here's your wetland buffer. That's your 100-foot buffer. This dashed line is your wetland delineation. Goes somewhere right here. So it's all the way on the other side of this paved road. And this distance from edge of wetland to edge of road is 64.4 feet.
So I just don't know that. This is the first time I've seen this drawing with this much detail. I definitely had a different understanding.
Well, and like I said, I would be prepared to move to approve this, but with some language about mitigating wetlands.
I actually would prefer to not do that because we need to go back to their wetlands consultant and get
A definitive.
some definitive answers. So it would be more appropriately a motion, if you as a body are on board with this, it would be a motion to continue with direction to provide clarity regarding actual proposed construction relative to the location of wetlands and the buffer, and then to identify additional mitigation. And it could also be that the applicant and their consultant are then coming back to say, well, no, we don't need to create more mitigation because I'm a little hesitant to just dictate more mitigation at this point.
Hallie, looking at these dimensions, I don't believe that one that states 21.62 feet. I think that's in between those two arrows.
Yep.
And I don't think we can say that that's how close the taxiway is.
No, the taxiway is right here, but you can see the wetland boundary right here. Inside, so there's taxiway inside the wetland 100-foot delineation here. And then that 21-foot boundary is just from edge of wetland to whatever the edge of this riprap is.
I'm not sure whose artwork this is, but it would probably be useful if Heather could give you a clearer picture.
Well, no, this isn't really a Heather thing. This is an applicant thing.
Okay.
And on that left-hand side, where the 64-foot is, that road is already existing.
Mhm.
That dirt road already exists there. They're not changing any of the condition.
Would
You
it
know,
be
as far as any
paved and would it be used more?
I'm not certain that it would actually be paved.
Well, it's actually an encroachment though. We just didn't know it.
Well, there is I mean, it was, that improvement was made when they built the runway and was covered under the 2005 wetland special use permit that was approved by the Board of County Commissioners at that time. And I just, as far as, you know, increasing any nonconformity, I don't think it's, at least on that side, that they're getting any closer to the wetland and it would have any effect.
Well, the northwest corner of what's shown as the West Hangar Complex certainly parks itself inside the buffer zone.
Well,
It might not. I mean, I think here's the buffer zone line, so it might not. But again, I think it's hard to say if it's this line or it's probably worth you guys doing a little more digging.
It would be helpful if the buffer zone lines on the map we look at is more clear. For sure.
Definitely would.
Yes, absolutely.
For the wetland application, yeah. Sorry to throw a wrench in things, guys.
Going on.
Lee, may I?
Yes.
I'd like to almost try to grab the wording that Kay stated about a continuance with answers to some of these questions. I think, you know, what's being asked of us is to specifically look at the wetlands, and we've talked about a lot of different things that are important and relevant, but now that we're looking in detail at maps, my question is, you know, if the original design of the wetlands was saying this is sufficient, you know, if they've been moved or scrunched over for the runway improvements or extensions or whatever, if then that was what was sufficient to meet the mitigation. But now if you've got an area that is dirt that can absorb rainwater and snow melt and whatever, and it's going to be paved and there's buildings with roofs and runoff, and the runoff of that west hangar is going to hit that road and, you know, right into that 100-foot buffer. And there was another map showing that, you know, the drainage of where these wetlands move down towards Deep Creek, you know, it's a bigger picture there. And I appreciate what Hallie's saying about, you know, if the mitigation needs to be because there's going to be all this new pavement and buildings that can no longer absorb moisture coming in, does there need to be an additional pond and a rewrapping of the 100-foot buffer? I mean, there's just a lot of technical questions that I personally would need more time to dive into and get some answers on some of this stuff. And so I would like to suggest Kay's wording of a continuance to get some of these answers.
Okay, I had another question for the applicant before we contemplate a motion. And that was some ambiguity around, is there a renewal of the quarry lease, or is it a done deal, or is it projected?
So Mr. Gallegos has requested a short I think they were 10-year increments on the agreement, and he is, right now, we're in discussion. His lease expires, December of this year, and so he wants to proceed with just really to finish up, if you will, of the work that they're doing. It's about a 5-year extension to their lease, because he believes that they have 2 years left as far as mining. And then they're storing currently a bunch of the material on pallets. And they would, as they slow down or scale down, they're gonna gradually remove that inventory of the material. And so a big thing, and this is where I'm concerned, is the remediation of that area, and it needs to be filled, it needs to be properly remediated and seeded and everything else. So, but that's all part of the discussion that we're just about to enter. And then they're finished.
And of course, we spent hours this morning talking about pretty much that topic. So,
Matter of fact.
not the quarry specifically, but remediation of mined areas.
And this isn't a gravel quarry. This is.
It's a stone quarry. It's
Stone quarry, yes.
It is construction materials, and yes, we have an SUP on it.
So what that means is that there would be 5 more years of use to access the quarry with that road that goes through.
Correct.
Where you're going to be doing construction, et cetera, on the south side, or potentially.
Potentially, yeah. I mean, we have to include that as definitely keep that area accessible during construction and what have you. So
And then how is that little road accessed now? Does it comes off of the main road? Is it gated?
It's gated, yes. There's a wildlife and there's an entry gate, a manual entry gate. And they enter off of Last Dollar Road to the east end, around the east end of the runway.
Okay.
You said we had an SUP on.
Yeah, it's totally separate from this.
But an extension of the lease doesn't impact that SUP.
No.
Okay. Any other questions for the applicants? From the commissions? Okay, if not, I'll entertain a motion. Did you want to make it, Robin?
I'll make it. I motion that we. Kay, you want to help me with the wording?
Okay.
Ask for
It would be a motion to continue to the May 8th meeting, because we don't have one in April. With direction to better identify the buffer zone boundaries and potential improvements within, and to determine if additional mitigation, wetlands mitigation would be warranted.
And if so, do we want them to come back with a mitigation plan if that's the case?
That's kind of goes without saying.
Okay. Does that work for you, Robin?
That works. So moved.
So moved.
I'll second.
Ally seconds. Comments and vote.
My only comment is that in addition to clarifying on the map that wetland buffer zone, it would help me a lot if there was a way to delineate what is already established and developed from what is potentially going to be developed.
Or improved, like if it's an established dirt road, but it's going to become a paved road. I agree with that, Jocelyn.
So you accept that friendly amendment?
Yes.
And Hallie?
Yes. It's a great one.
Okay. So we've got 2 yeses.
Aye.
And a clarification. Robin?
Aye.
Hallie?
Sorry, aye.
Chair votes aye. Okay, moved, seconded, and approved. We'll pick this up again at the next meeting in May. All right, it's been a day. Anything else from the staff or from the commissioner? Is that a no or a please no?
Please, God.
All right, thanks for attending, all you who were on the call. And we are now concluded. Meeting is hereby adjourned.
Thanks, Lee.
Oh, of course.
Thanks, guys. See you again in a month or two.
All right. Good luck with tax season, Robin.
Yeah. In Bali.